I'm hiding in plain sight.
All right, let's go ahead and get started then. Do you have anyone participating telephonically today? Doesn't seem like it.
Don't you?
Eric, can you hear us?
I sure can.
Oh, okay. Is that Eric, our friend Eric? Committee member Eric?
Yes.
Hi, Eric.
And Eric, you also have a member of the public with you?
Yes, I do, until his appointment is approved.
And can he identify himself?
Yes, this is David Carr.
Oh, awesome.
Hi, David. Thank you for joining us.
Thank you for having me.
All right, well, let's go ahead and do roll then.
Okay, Andrew Dilworth,
Here.
Amy Bonsi,
Here.
Kendra Basler,
Here.
Stephen Bundy,
Here.
Suzanne Spencer,
Here.
Eric Dietz,
Telephonic.
Justin Fields,
Here.
Matthew Hodel,
Here.
Joel Osman, Marlo Richardson, Dina Roche,
Here.
Teresa Schmidt,
Here.
Rujvala Singh,
Here.
Richard Solomon, Steven Sparta,
Here.
Marshall Whitney. Okay, thank you.
All right, is there anybody who wants to be heard on public comment? All right, let's move along to announcements then. Andrew, anything on announcements and staff report?
Sure. I don't really have too much to announce this time other than this is the last meeting of our current committee configuration, which is always one of melancholy. Yeah, melancholy. Or just general sadness. Just stay more clearly.
Bittersweet.
We will be losing Suzanne, Joel, and Ujvala. And as you all know, I'm always careful to say on whose behalf I can speak, which is usually only myself. But in this one instance, I think it's fair to say the State Bar and all the staff of the Office of Professional Competence really appreciates all the volunteers who serve on the committee, and especially the three of you who we will be losing this year. And we will miss you. We want to just say thank you for all the hard work, time, effort, and fun that you've provided to the committee over 3 and in some cases 6 years. So thank you all. Which leads me to a nice transition that next year's schedule of meetings has been finalized. And if you're so interested, staff has printed it out. So next year's meeting schedule here, I'll just take one, pass it around. It'll also be emailed. We will send an email to the new committee members. So Mr. Carr, don't worry, there will be a staff email coming to you and all the other newly appointed members, as well as the committee members will be carrying over to next year. There will be an administrative email which will contain the meeting schedule as well. And then lastly, on a more substantive note, the State Bar last week submitted proposed Rule 1.2.1 as revised. If you'll recall, Comment 6 was sent back from the Supreme Court for further revision. The Rules Revision Commission did that revision, sent out a revised version of the rule for public comment, received the public comments, considered those public comments, approved a rule to be sent to the board. The board adopted the rule in July, and as revised, and the rule has been sent to the Supreme Court. In the rule request, we ask that the rule be made operative on November 1st so that it's in time with all the other rules that the court approved back in May. So that is our hope. And that's all I have. Maybe, did I miss anything? Or do you have it?
No.
Andrew, is Steve one of our departing committee members as well?
No.
Oh, okay, good. I don't
We
know.
have 2 public members then.
Yes.
We
Okay.
will have
Good.
2.
I didn't want to leave Steve out,
No?
but I'm happy that I'm wrong.
Thank you. Steve's got 1 more year.
So
Excellent.
Who's Roland? Joel. Joel can't be with us today, unfortunately. Yeah. So there was a fourth member, Marlo Richardson. She was a public member. She no longer was participating in the committee shortly after her appointment, so we've been going with one less committee member.
One other quick question. I know you had circulated some information to leadership of 1987.
Yes.
I was going to mention that at some point. I don't know if you want to do that now as part of this. Or
Sure.
do it later, but it's probably worth just throwing out sort of the basic.
Yeah, no, that's absolutely a good idea. There's Assembly Bill 1987 was passed in the Assembly as well as the Senate, has been sent to the governor's desk. I've not heard that the governor has signed it. I don't have the text in front of me, so I apologize for not being as specific as I should be, but there is a section in the legislative language which directs the state bar to conduct an analysis as to whether the termination of employment rule is specific with respect to retention of criminal files of a client, a criminal matter, specifically post-conviction hearings. And so if you go down to section 3, I think, is that, yes, right there, section 3. So Mimi is projecting the bill language. And so the state bar will be asked to study whether the rules are clear as to who's required to retain client files in a criminal matter. So
yeah, my quick read on it was, so basically the legislation is making the point that it's important post-conviction, especially in certain types of cases, for clients to be able to have access to files. That's an important public policy, and it helps promote people who are innocent staying convicted, things like that. So the gist of it, and I'm totally paraphrasing from having glanced at it earlier, but it basically says that if this gets signed by the governor, that they're going to ask the state bar to look at the rules that are applicable to file retention and file disclosure to see, you know, how they sort of jive with this concept that it's important for X period of years after someone's case to have access to post-conviction records. And I think, if I haven't studied in great detail, but it might not be just like prosecutors. I think it's maybe prosecutors and criminal defense lawyers.
correct.
And I think that they talk about some kind of time period, if I remember correctly, like 10 years or something like that. So, you know, the gist of it is, are the rules as they exist consistent with promoting this goal, or are lawyers able to do something under the current ethics rules that would not have files maintained or accessible in a way that we think need to be accessible for these types of situations? And if the state bar's determination is that the rules they're not consistent with promoting that, then there may be a request that the state bar, you know, asked to promulgate some new rule or rule provision that would modify whatever the existing ethics requirements are to facilitate that.
That's correct. So it'll be a study of the newly adopted rule. Is it specific? Is this issue addressed in the rule? If not, in what other authorities is this obligation addressed? And there is a file retention opinion that co-practice put out. In that they talk about estate planning documents. They talk about you should maintain files generally for 5 years. However, there's an exception for criminal defense and estate planning documents, as they may have a value of greater than 5 years, particularly in California where there's 3 strikes initiative and a second or third conviction of a client, that earlier conviction might become quite relevant beyond 5 years. And I think there's an LA County Bar Ethics Committee. So all that to say, staff can help aggregate those authorities, but this committee may be asked with doing analysis, drafting a report as to what the landscape is for the ethical obligations, where they're found in California, and could the rule be specified in light of this legislative change. So there is a legislative change within the statute as to who needs to retain and how long. And then Section 3 is of the legislation is this additional component requiring a study of the rules of professional conduct.
I mean, for purposes of today, I think the gist of this is it's a heads up.
Exactly.
It's expected that it'll probably get signed by the governor, and once it does, they're going to go to the state bar, and the state bar will then ask this committee to help facilitate Section 3. So just a heads up that it's probably coming, and if there are people who are particularly interested in this issue, let us know. I mean, assuming it comes to the committee, we'll have to figure out, who's going to be on the subcommittee to help sort of facilitate that report. So just want to make people aware of it. So.
Exactly. Thank you for reminding me.
Sure. All right. So the open session action for the July meeting is in the materials that were circulated in advance of today's meeting. You can take some time to look at them if you need it, if you haven't, and if there's someone who has a motion to approve them, let us know.
The minutes were
The open action summary from July's meeting. It's pages 1 to 4 of the materials. Is there a second?
second.
Yeah.
All right. Can you vote? Andrew Dilworth,
Yes.
Andy Fonsi,
Mm-hmm.
Kendra Basner,
Yes.
Stephen Budney,
Yes.
Eric Dietz,
Abstain.
Justin Fields,
Yes.
Matthew Hodel,
Yes.
Joel Osment, Marla Richardson, Tina Roche,
Abstain.
Teresa Schmidt,
Yes.
Ujvala Singh,
Yes.
Richard Solomon, Ethan Sparta,
Abstain.
and Marshall Whitney. Thank you.
Okay. I want to start this morning with 12005. This is seeking advice about current clients, pages 25 to 47 of the materials. The red line, I believe, starts at page 36. And you may recall from last meeting's discussion, one of the things that we wanted to do with this opinion, which has already been out for public comment previously, was to conform it, as we're doing with some of the other opinions that were already out for public comment, to the new rules. Amy is the lead on this, although Steve had volunteered at the last meeting to take laboring work, at least initially, in trying to make the draft revisions regarding the new rules. So I'm not sure, Steve should know. Maybe Steve, you should explain those revisions. And then we can talk some more. We did have a subcommittee meeting already in advance of today's meeting to discuss them.
Okay, so would you like me to?
Yeah, if you don't mind, Steve.
Well, let me start with I'm a little embarrassed, more than a little embarrassed. There are some typos in here that, at least as I was reading the red line, that I should have caught. Let me just run you through them quickly, okay? And then, so at page 4, line 118 and 119, 170, 118, I struck, in my haste, I struck the language, the attorney, and that should still be in there. It should say the attorney should also consider, and I apologize, that's number 1. They get worse. So jumping over to 306, right? Once at 306 to this is actually 308. Consistent with Rule 1.70, law firms should not, it should say, continue to represent the client, right? And should not continue to represent the client unless, is that what it should say? And at line 312, if law firm concludes it can ethically continue to represent client, it should seek the clients.
It's here.
What?
Seek is not there.
It's not, it is?
Yeah.
Not in my language, not in the draft that I printed up
No, it's in
yesterday.
the middle.
What?
It's in the middle of the
word
struck out
C.
part.
Oh,
Yeah, I didn't see
I'm
it.
better than I thought. Okay, good.
It's hard to read that.
That's so nice to not actually find that. At line 382, these are technical. Line 382, the reference to Rule 3500 should be to Rule 1.4A3. And that 388, there should be that parenthesis is messed up.
Yeah.
Okay, those are the things I caught reading yesterday, and I apologize for them. Essentially, I don't want to spend a lot of time. Basically, the goal here was simply to update the opinion with the new rules, and that doesn't actually change any. In my view, it doesn't change any of the opinion in any material way, but people may disagree. But I guess the thing that struck me is that the one thing that might be considered a substantive change is that 1.4 really has more prongs going than 3.500 does. Right? More ways of thinking about how your duty to disclose can arise. And 3 are potentially implicated here. 1 is the sort of carryover from 3.500, which is you have to disclose the significant developments, essentially, and you have to do so in a manner that the client can reasonably understand them. That's not really a change. In fact, I don't think any of it's really a change. But what's interesting about 1.4, beside that, right, is that it adds these, it makes explicit that you also have to inform with respect to limitations on representation, at least when the client, you know that the client expects you to provide advice and you're not going to provide it. You have to say, well, you know, I know you expect this advice, but I can't give it to you. And the other is that it's expressed that you have to inform with respect to transmit anything that is a matter of informed consent, right? So the rule now ties in a way with the conflict rule in a way that is tighter and more explicit. And I tried to take account of those language changes in the drafting. And I think at that point I'll just open it up. That's, as I said, I don't really think the opinion changes materially, but people may disagree.
So I guess we will start with the subcommittee, which is Amy, myself, and Suzanne. You guys mind if I go real quickly? Mine are really pretty minor. So my first comment is on page 3 of the red line, starting at line 101, and this is an issue that we discussed in the subcommittee meeting. And I'm wondering if we just didn't make the change or if there was a substantive reason, but on 101 to 102, it says the duty of communication requires, among other things, the attorney to disclose the material facts potentially giving rise to any legal malpractice claim against the attorney. Then down on 108, we say an error giving rise to a legal malpractice claim is a significant development relating to representation. And
You
I
want to
thought-
add potentially there?
Yeah, I thought we had discussed that.
We probably did, and I
Make them
probably
parallel.
missed it. I regard that as a friendly amendment, so why don't we just make that?
Potentially.
So that's on 108, after error, it would say an error potentially giving rise to a legal malpractice claim. So the language is parallel essentially to the language in the very first sentence of 101, 102. Sorry, these are just nitty, but it's close. So on page 5, line 149, it looked to me like there was an extra period.
There is an
Actually, actual rule too.
Strike that.
Model rule.
Oh, yeah.
Do you know about right there? I think it's model rule A2.
Huh? This one?
Yeah.
Do you want me to double check or do you want me to just change it?
I mean, I don't want to be overly confident.
No, let's just check it.
Because I think the California rule, B comes from A2.
Okay.
Well, or at least let's see what model rule 1.7 is.
It is A2.
Oh, it is.
It is.
And jumping over to page 9, starting at line 285. I think this is just, there's a
Oh, I missed that typo.
residual
There's some typo.
language.
Yes.
Yeah, that day probably comes out.
Exactly.
Lawyer and law firm have a conflict of interest. And then on
I would
287.
just put a period after them, don't you think?
So it'd say to seek other counsel to advise them. Is that
Okay,
right?
them, and just strike the rest,
Period, yeah.
period. Yeah, I think that's right. And I meant to highlight that one, didn't.
I'm sorry.
You're on that sentence,
Line
285.
286, act 286, 287.
Because I didn't understand that sentence well. Lawyer and law firm
That day is strict.
Should say have a conflict of interest, and should advise the client to seek other counsel to advise them.
advise them.
Or advise.
So take
So
out
on
on
issue.
those issues, or
Yeah,
just take it
Yes.
out?
Yeah.
another of my typos.
And you have to get rid of on at 287.
Advise them.
And then down in the footnote 12, I think it's the lawyer reasonably believes that he or she could provide. Is that typo?
Yep.
And that's it. Yes, sir.
So, I don't have a ton of comments. I thought in the duty of loyalty discussion, we, at lines, 126, 127 of the red line, we say the duty of loyalty is reflected in the rules, including Rule 1.7 and case law. I think that's kind of a holdover from our old rules where we had to, I think basically it's reflected in 1.7, right? It's now clarified and we don't have to dance around. So what I'm just suggesting is that we say the duty of loyalty is reflected in California Rule of Professional Conduct 1.7, as well as case law and common law.
I'm fine with that. I mean, it's also reflected in 1.8, among other things. Rule 1.8 is a duty of loyalty rule.
Okay, well,
So-
all right, then that's fine. I felt like it just, okay. So what does 1.8 do?
It's all of the specific sort of weird variations of the duty of loyalty, like attorney-client business transactions, like co-client, settling agreements, all that sort of stuff.
Right. Okay.
So it's basically like the ABA approach.
Yeah, no.
The general one and then
The
the
specifics, yeah. All right, well, that's fine. I mean, we can do it as including. Then we say, so on 169 to 170, you say, written, where there's a significant risk that a lawyer's representation of a client may be materially limited, the conflict of interest may exist. Is that right, or is it that it does exist?
I think logically it probably should say exists.
Okay, I think that's more consistent.
Where's it? Sorry, because
So-
my computer died, so it doesn't take
Yeah,
notes
well-
for the moment.
I'm sorry, I was distracted.
All right, so it's 169,
Got it.
well, it's,
171.
sorry, it's 171.
Okay.
We're just changing what, in the middle of that line, it says a conflict of interest may exist.
Yes.
You see that, we're just to take out the may and make it plural, exists.
You make a prior revision as well.
Sorry?
Your comment
No,
preceding this.
we didn't make
Okay.
any revision. That's
Also,
it.
Eric, my computer died for the moment, and I'll be back on in a second.
Yeah, I saw that. It
Oh, no, I'm sorry, there is one more.
says I'm now the host.
Like you.
So, I'm sorry, I'm bopping around, but I'm going back now to the discussion of the duty to communicate. And after you quoted the rule, we
Yeah.
have a big paragraph there.
Yep.
And we're saying that you have to disclose material facts giving rise to a malpractice claim, and then this conclusion is supported by 1.4a, which I don't know.
Would you say?
I would say C, because I still think C is the driver of the duty to communicate.
A3. right?
A3, sorry, not C, A3, exactly.
Yeah, I'm happy to have that fine.
Oh, I see, that's, I'm sorry, because I was confused about the numbering, so I thought, I was confusing, thought we were citing specifically to 1. No, I mean, I don't mind if it's a general citation to 1.4a.
I actually like that better for the reason that Steve articulated earlier on, which is there's arguably multiple
I agree.
subcomponents that.
Right,
So leave as is.
yeah. So, I don't really have any comments, I think you did a great job.
Yeah, I agree. I really think you did a great job, Steve, sort of intertwining it pretty seamlessly. And I especially liked pointing out that subtlety between, even if you don't have a conflict that may significantly, materially affect your representation of that buzzword, that you may still have this duty to communicate separate from that. And I really liked that. I think you teased that out really well. And other than the little, little typos here and there, which have all been picked up, the only other thing that I thought we might want to consider is at page 4, we took out the citation to Oasis West Realty, but I think because, I just think we might want to do a C also and not take out Oasis. I know it's not directly, I just think whenever we can point people to authority that may be around these issues, it's better than not. And so the way you have it now, you have Santa Clara County, construing former rule 3-310B4, and And I would consider saying C also, Oasis Strat West.
What line are you on?
142 to 145, we took out, but you know, the principle there, which is that, you know, you have a duty to disclose where something may substantially affect the exercise of the lawyer's professional judgment, is still consistent with the current rules and duty to disclose. So I just think it's helpful. I don't think the quotation is necessary, but at least pointing them.
Just adding in C also.
C also, Oasis, and you probably don't need the quote. but-
I'm fine with that. I think that, if nobody else has a problem, I think that's fine. I think you're right, that
It's in
it's
there.
good for people to be able to, right, just look at that. It's a very important case, and it certainly hasn't been vitiated
Right.
in any significant way by these rules.
But that's it. I thought you did a great job.
So we're putting that back in?
We're gonna put that site back in just as a C also,
After the Santa Clara stuff.
after the
I just,
Santa
I
Clara
don't
site.
understand what we're citing, what we're saying, it's a C also to. It's a C also to what?
The principle that's there is that, you know, the primary prophylactic purpose is what it is, right? Which is to prevent situations in which an attorney might compromise his or her representation. And the relevant part of Oasis is the part where it's talking about a lawyer should disclose any personal relationship where it could substantially affect the exercise of the lawyer's professional judgment. So it's the same concept articulated slightly differently, similar to what Santa Clara is saying. I don't think we need to repeat what Oasis says, but the idea being that where your independent professional judgment is, there's a significant risk, you need to disclose, independent of any, you know, according to that case even.
But this is the section on duty of loyalty, not on disclosure.
Well, what, I'm not quite sure what your concern is.
I don't know what we're telling people when we say see also Oasis. I mean,
Okay, well, so maybe we should,
I'm not saying we need, I just want to understand it, because Oasis to me is a very confusing case, and I'm not sure what the principle is that we think we're telling people that they should go with that case for also.
To me, the idea that where there's a substantial risk that your professional judgment will be impacted, you have duties.
That wasn't a license, right? The client relationship was over. It wasn't a consent issue. It was an issue of whether the lawyer could take the actions that he was taking on his own individual behalf, given the prior relationship that had existed, and whether that would undermine whatever residual or continuing duty of loyalty existed by virtue of the form of representation.
Right, but I mean, my understand, the language that we quoted that we took out is directly on point to what we're talking about. So I was just saying, I don't know that we should, because they're talking about duties that may arise when your independent professional judgment may be, you know, adversely impacted. And that part of it, I do think is still relevant. If you're worried that because, and it's true, it is a confusing case, and, you know, maybe putting that quote back in, it just seems to me that that concept is one that's important, and it's now in the new rules, which is great, but wherever we have case law on it, it may be helpful.
how about, I'm wondering if we can meet the, I think, very real concern that Amy and Drew are raising. Could we say, with a parenthesis, see also, cite the case, and then parenthesis, requiring disclosure of, and then the language that you want, any personal relationship interest the lawyer in a reason should not substantially exercise.
I think that's helpful. It answers Amy's
Yeah.
question of
Yeah.
what are we telling them to look at the case for?
Yeah.
Right, because Oasis has complicated things about what the duty of loyalty is and post-representation.
Yeah, we don't want to drag any of that
Yeah,
stuff
yeah, I was
in.
just trying to pluck that language out of it without.
So maybe if we just put it in a parenthetical, that would explain why we tacked this site
Okay,
on.
got it.
Okay,
Sure.
I think that's great.
Do you want me to use all of this or just
No,
up to them?
just let's look at it, requiring disclosure of any personal relationship or interest, that it would go for interest the lawyer knows or reasonably should know. Go all the way down to professional judgment.
So you want it all?
Yeah.
That's what I was asking.
Yeah, you're right, we do.
I have a related question to the section when you're done discussing this paragraph.
Was Oasis a disclosure case though? Wasn't it just about?
it wasn't, that's why I was surprised.
That's why
I
we're
guess it-
putting the
So I
language
don't think
in.
the parenthetical is,
Well,
you think the parenthetical is really what Oasis is?
No, that's why it's a C also.
well, but is, are
That's
you
why
saying
it's-
that was kind of dicta in Oasis? I mean, I don't even
It is
remember that
dictum,
part.
it is dictum
Okay.
in Oasis, I would say.
Right, so.
It's just helpful language.
Right, I'm okay with parenthetical, because I think the holding of Oasis doesn't have to do with that.
It was about actions you take after you stop the representation.
Now, I totally agree.
Adverse to the same subject matter on which you represented the client.
I'm perfectly willing to take direction either way. I don't have an ownership interest here. How people feel. Maybe we should just, it's certainly not essential at all
Right, I mean,
to the
because
argument.
yeah, I mean, the thing is, we used to have such a hard time with this section because our rules were so inadequate. But now we have really, really crystal clear rules. And so, I don't know that it added too much.
You could put in front of it which discusses disclosure of or required disclosure of, just if you're concerned that the impression is that that's going to be the holding of that opinion.
Well, I guess the thing is, if you, I mean, could someone go into court or go in front of could someone assert that you had an obligation to disclose and cite Oasis as the authority for it?
Not under a current, I wouldn't think under a current client conflict situation. I think I read it as Drew described it earlier. It's a former client conflict situation, which does require consent in certain circumstances. But, and that being said, I'm not sure it fits as neatly in this discussion the more we talk about it as we initially may have thought.
Suzanne, I'm going to suggest that we take it out because it's not worth it.
I'm just reading it. So that part of Oasis is a reference to the requirement under 3-310B to disclose.
It's kind of statement of portable law. in a way.
Right. And
But
so-
not really necessary to the decision.
Right, but it does, it says in as much as the attorney was obligated under 3-310B to do that.
Right.
My thing is this, and I'm not overly married to it, but there are certain principles that are now in these rules that we used to have to hunt for before. And I think it's great that it's in the rules. But I also think it's helpful to point people to where it was already in our case law. And so that if they're wondering, has anybody ever interpreted this language, or where did this language come from? Let's put this language in context. If there's a case that has that concept in it, it's helpful. Do I think it's, essential to this opinion? But I think it's helpful to point people to it. It says what it says. It doesn't say that that's the holding of the case, or those were the facts. But the court says what it says, that he was obligated to do this thing. So I do think it's accurate as it's written, but I really, I'm not going to throw down on it, but I do think it's helpful to people to show them where this language comes from.
Where what comes from?
The professional, so the exercise of his professional judgment language was not ever before, it's in the new rules, it wasn't around before we have it. Like what you had to do in a 3-310B situation. Because this is talking about the 3-310B, that, you know, this is what we're talking about in this paragraph. I think it is talking about the very same thing. And, you know, I just think that means that cases that are interpreting the rule in its prior iteration are still going forward.
I think we should have a quick straw poll.
Yeah, I mean, I don't think.
What's the sense of the room on whether this should stay in or not? This language, assuming that it, or go in or not, well, we give it.
It's probably more like.
Those Suzanne, those who take Suzanne's view.
This is the question of the, I'm sorry.
This is the language, so we can move on because I think we're getting hung up.
It's just whether or not we're gonna add the site to a nuisance.
Yeah, and it should probably say stating that disclosure.
Right, stating.
Because it doesn't require disclosure, it's stating that disclosure.
So I don't think, but no one in the room feels that strongly, but we should just do it. So people who would like to have it stay in with Suzanne, anyone else? Ushvala? Those who think it should come out?
Those.
I think they come out hasn't, right? So let's just take it out.
Yeah. Let me add my vote to the remove.
Okay.
So I have a question on footnote 3, which I just read the first time, which is still contained here at the end of the sentence. The end of the third line of footnote 3 says, as defined in Rule 310B4. My suggested fix would be to start with a parens before as. So parens, as defined in former Rule 310B4, parens, and then cite to the ethics opinion, but that's just a quick fix, I'm not stuck to it.
Here.
No, before as defined. And then, yeah.
As defined in.
Oh, and then former in front of Rule 310B4.
Yes. I think that's a good fix.
I didn't see it before, but
No,
as you guys were
it's
talking
a-
about, I'm like, oh, what's this footnote say?
It's a good
And it's
catch.
just citing to the ethics opinion, but.
It's a good catch.
Are we done with subcommittee comments?
I think so. The subcommittee is now.
And I think that's everybody.
That's it.
We'll open it
Sorry.
up.
Yeah, so.
I have a question about, this is on page 44, which is the red line. I phased out for a second. Did you already cover it? There seems to be a word missing at line 285. What is the word that's missing?
Oh, it's not, it's more than that. It's like a catastrophe, an editing catastrophe. In the version that you're looking at, Matt, that we've taken out that they at page 285, or from have a conflict of interest and should advise the client to seek other counsel to advise them, period. And then,
Wait.
Yeah, that's-
Should I look at the clean one to
No,
understand?
we just
No,
finished
fine,
it.
there.
I'm sorry.
So it's right, what we fixed is right here, but make it clean if you want it.
Right, okay, all right. So
See it clean, it's like that.
my comments on it, I mean, I think it's good if you agree. And I think the drafting's great, but I don't agree with it. I want to step back for a second. In reading this again, it still suffers, and I think it exacerbates the problem that we discussed previously, that it really does lead some people to conclude that every time you think you potentially have committed a mistake, even if you think it may or may not be malpractice, you have to tell the client that in fact you do have a conflict, and that you need to have a conversation where you explain to them why there's a conflict, and you need to explain to them that it's your concern that someone could say there's a malpractice claim. And we had that discussion about whether that subject matter should be mentioned, and I think that this draft moves. I thought we sort of cured that in a way that made it, in our last discussion, made it ambiguous and then satisfied both schools of thought. Because I do think it's an open question whether you have to use the M word, as we said in some of the one of the written submissions came from Orange County in particular. And I think that this moves away from that in a way that's I think is dissatisfactory and compounds and creates uncertainty, as we discussed last time. I want to go back. I thought about this some more. I mean, there are situations where there is such a conflict, where if you want to continue to represent the client, you need to have, I suppose, a specific discussion where you make sure the client understands why there's a conflict. I think maybe I finally got to what I think this opinion suffers from is, under these facts, they failed to file a cross complaint. It appears to be barred by the statute of limitations. The school, the jury, if you will, is still out on whether in fact, it was malpractice, because it may not be damaged. The client may not suffer any damage. Without damage, there is no malpractice. So I wrote down, well, why is there a conflict? Maybe there is a conflict under these facts, but what this opinion doesn't do, it doesn't inform the reader as to why there's a conflict. It just says there is a conflict. Sometimes it says there's potential for a conflict. But then it says because you went and got advice from an independent counsel who's told you that there may be a claim, you now have a conflict. I thought, well, I've seen authority that says that the interests you have with your client in these situations sometimes dovetail. And I don't know why under these facts, and you can tease out a hypothetical now, maybe we should, and maybe that's what this opinion needs to explain to the reader why there is a conflict. Because it doesn't explain in here why there is a conflict. All it says was cross-complaint potentially barred by statute of limitations. Maybe there's malpractice, maybe there's not, because there may be no damages. But okay. And from that, all roads in the rest of this discussion lead to saying to the client, you now have a conflict, you can't go forward, you need to have a discussion, and you need to get consent. That doesn't follow from this hypothetical without an explanation. So it makes a broad assumption that then states a broad rule from basing. I think people will be confused by it. I think they'll say every time there's a mistake is made, even if we don't know what the consequences of that mistake are, because it's potentially the client may have a claim, they don't know whether to do it or not. No one will ever know unless something else happens. That I need to go have a discussion and I need to be very explicit with the client. So I think what this opinion could improve by informing the reader as to why there is a conflict under these facts. I mean, tell me why there is a conflict.
Can we just back up and remind ourselves what this opinion is about? Because that's not what this opinion is about. This opinion is about what you can get advice on and when and how to proceed, right? So there is a small portion of the opinion that goes into the question of when you have a conflict, what do you need to do? And I could look at it again, I think we could, and say, do we make it clear? But it's sort of, to me, it's like Suzanne's opinion, where she said, assume this situation. You have a conflict. Then what do you need to do? Then so I mean, again, the premise here is also, what we're really trying to grapple with is when can you use in-house counsel to guide you on this? And I mean, that's the intervention this opinion tries to make. And the reason that it's important then to talk about what happens if there is a conflict is that becomes particularly touchy with respect to having in-house counsel who also lead to the client, right, giving you guidance. Right. So it's, in a way, this opinion is not about fundamentally what are the steps you do, what are the steps you take when you make a mistake. This is about what do you do up until the moment that you make a mistake. And then it says, okay, when you get to that point, let's assume you get to that point, then there are some other things. So I just think it's, you're analyzing it, it's quite focused on this one issue as if that's what the opinion is about.
The overall context of the opinion is when do you have to tell a client you had a conversation with another lawyer where you sought legal advice. However, the opinion spends its...
No, that's not the core question. It's never been a core
The
question.
question is when can you work with in-house counsel to figure out what you screwed up?
Okay.
Yeah,
But I don't think you can deny that it, to a significant extent, it talks about the disclosure that needs to be made to a client where you have a concern about malpractice. So we can't ignore that. I appreciate that it has that overall there's a broader purpose, but along the way we are addressing exactly that point, which is what,
Right, but
regardless of whether you sought legal advice, Amy. I mean, because this opinion, I mean, even if you conclude in your own, I conclude I committed malpractice, I concluded damages the client, I don't need to go talk to another lawyer about that. I already know it.
Yep.
Someone would say, well, you want to know what you do? Go read this opinion. Like, good. It tells me I can go talk to their lawyer, confirm what I already know. But it also informs me that I need to have a discussion with the client. And
you don't think you do.
But you do. I mean, that's clear under existing case law.
and
There is a comment.
Andrew, the existing case law says you have to disclose the facts.
Right.
It does not explicitly say what this committee appears to some people in the future may think it says.
I guess I don't feel as strongly about this as I used to, and I understand your concern. It's very difficult, though. I mean, I think that the new rule makes it almost impossible to argue that you don't have to say, "I'm sorry, I can't advise you on this." I just don't see where the wiggle room is. In terms of how you could say otherwise. That language that's quoted at pages 286, at lines 286 to 294, doesn't leave you a lot of room to say that you don't have to say that. Where do you think?
To address what you said about the new rule, you're talking about 1.4A4, I think?
No, I'm talking about all of it. There's A1, there's A2, there's A3, there's A4. It's like, and then there's B. It all piles up, and it just creates. I mean, it's not enough to say case law doesn't say that, because you now have A, and B, and the language just doesn't leave the lawyer with a lot of room.
I've heard lawyers.
I mean, if you would be. I mean, I'm not saying there's not a non-frivolous argument, right? I'm not trying to rule out the possibility that there's a non-frivolous argument in that, but you'd be asking somebody to walk a plank if you told them that they didn't have to say that, and that they didn't have to.
I would need the facts on it.
What? No, on the question of whether you have a conflict in whether you have to disclose that you can't advise concerning the claim. I think you'd be.
Well, you wouldn't give any advice concerning whether they had a claim or not. You would absolutely steer clear of that. I think that's.
No, that you obviously can't do,
Right.
right? But the question is whether you have to tell them that you can't advise them in so many words. That it seems to me it's very difficult to say you wouldn't have that.
What is the? But I look at 1.4A4 that talks about significant relevance. I think this is what is it? Let me make sure I understand. For A4, advise the client on any relevant limitation on the lawyer's conduct. The fact of a potential malpractice claim has created a limitation on the lawyer's conduct, right? on what the, but that limitation's always there. It hasn't created a new limitation.
But you have to tell them about the limitation. The rule says expressly.
So-
Again, I don't know that you need to do that in every circumstance, and I think, I've always thought that's the flaw in this, that it takes a rather generalized mistake. We may have a claim that may be time barred now. There may not be any damages under this hypothetical. And at that point, I would say, well, I need to know more. I'm aware that the lawyer's interest may perfectly dovetail with the client's. I mean, tell me what harm a lawyer can do to a client upon these facts where the lawyers. I mean, I like to hear it because there may be I mean, wouldn't that help this opinion to explain to people? Because I scratch my head and go, I think I can fantasize about what a lawyer might do in the shoes of this hypothetical lawyer, given that, gee, the cross complaint's been barred. Maybe I don't want to call attention to that fact. But I already did. I've told the client that it's barred.
Okay, wait, stop there. So you agree that you need to tell the client that it's barred, right? You need to have that conversation,
The facts.
right?
The fact that we have a claim, it appears, it wasn't filed on time, it appears that it's barred. You may have lost a damage claim as a result. You may not be able to assert it here in this case.
Okay. All right, so are you arguing that at that point, I mean, there's two things I don't quite understand. Are you saying you're worried we're telling lawyers that they have to say, and you may have a claim against me, and I can't.
And I can't tell
advise
you.
on that?
The
Or are you saying, sorry to interrupt, or are you saying that you don't even think that you have a or are you saying you don't think you have a conflict that you need to get consent about?
We'll take the second one first. Do you
Okay.
think you have a conflict? I couldn't tell either. I thought maybe
Yeah.
you were
Well,
saying
I-
that's not necessarily a conflict because maybe there's no damage, everything else. But you have to disclose the facts. You have a situation where you know that this is likely now a time bar claim. That's a product of your conduct, your services as the lawyer. You know you have to disclose those facts. You disclose the facts. I think we agree on that. Is there a conflict at that point between the lawyer? Just with that, is there a conflict between the lawyer and the
What
client?
if I said, Andrew, we're going to seek a writ, we're going to appeal this, we're going to do everything we can to restore this claim to the case.
Right.
That's-
You're
So
not
where's-
answering
so
my
where-
question, but I'll answer your
Well,
question.
it-
My response would be.
Tell me what would I do that we could,
We may have a common interest moving forward in trying to mitigate any potential damage from the error. But
Correct.
the fact of the matter exists that there's an error that I created as the lawyer.
Right.
And I think that creates a conflict, even if we have harmonious, goals to try and mitigate that. I
Tell me what
think
conflict.
you can't say
Who's gonna pay
it's
for it?
it's dependent on damages and that proving up, and so, I mean, malpractice cases, lack of damages argued all the time, and that's way after the fact. I mean, you can't, then a lawyer can sit around and say, hey, maybe they'll never tumble to this, or maybe I don't think you have to satisfy every element of a malpractice claim to say, I have an ethical conflict for purposes of making a certain type of disclosure to the client. I think you have a conflict in this situation.
Remember that the standard for
Doesn't-
disclosure is may materially impair your judgment and services. It's not that it's not meant that there's an argument or even a good argument
Tell
that
me-
it's not going to
Okay.
play out that way.
So, but Stephen, so under these facts, tell me what a lawyer in the shoes of a hypothetical lawyer, how the lawyer might be tempted to do something that's adverse to the client's.
Well, there are two
interests. Once a lawyer has said, has made at least a partial confession, in the sense that something bad happened on my watch, it potentially has caused you damage.
Right. Well,
So the facts are all there.
yeah, I do think me just start by saying I think that Amy is right, that we're really not, we're trying not to go there. That's a huge swamp. But having said that, there are so many ways that your judgment may be materially impaired, right? It might cause you to recommend a particular course of action in the trial of the underlying case or settlement of the underlying case. There are a range of different kinds of things that you might do.
Might recommend to try to mitigate the damage that you
Right.
cause. That is a cost to the client, let's say, and unless you tell them that, the client might prefer to not have those costs incurred. So just the expense of going down one road would be something that would have to be discussed.
Or not mitigating. the
Or not
damages,
mitigating.
Which would be a
So your
defense to the malpractice claim.
point, so your point would be, I may in a self-serving way say, well, we
I
need
think I
to,
can
we
fix
need to
it.
stop the case, we
Yeah.
need to pursue a writ, we need to do everything we can to try to restore this claim,
Right.
which is attempting to mitigate the effect on the case. And you're saying that that action, which is in the client's interest, because this presupposes.
It's in your interest too.
Yeah, in your interest dovetail with the
No,
client's.
not necessarily.
But this
I'm
is-
sorry, he could fire you and sue you
Right.
and get everything,
Right.
and probably it's an easier claim for him to make than proving the breach of contract against the third party.
The point is, you have to disclose it and have those communications.
Matt,
And the client makes a
though
decision.
if there's an overarching point, and I really agree with what people are saying, the overarching point is that the choice of the next step is a matter of judgment, right? And so you, when you say, oh, well, our interests are perfectly aligned, that reflects the end product of a professional judgment. That's that, and that professional judgment is tainted by the potential conflict. It's that you can't.
So
reach
the mere
you
fact of
can't
concluding that there's no conflict in and of itself is a conflict situation. That's.
Yeah,
that's-
our interests are
that's just a
perfect.
tautology.
Our interests are perfectly aligned, right? And therefore, I don't have to say anything to
But
you.
you make the decision every day on a
No,
on a variety of subjects.
but the reality is that
Yeah.
you're burying the problem that way. That's a good way of burying the problem.
And
Right.
it's the judgment,
It's fine because, and then and that's a line of analysis. But we all, as lawyers, know that there are many lines of analysis that run through a problem.
Right, and then at that point, the client doesn't have the information necessary.
They don't have it, and
its own
you've in
analysis.
effect, I mean, I think that in that situation, now you've said, now you're in breach of your fiduciary duty.
Yeah, what people need to realize too, I've heard exactly that argument made, which is that this is a great argument for plaintiffs' lawyers, I think. And it may well be the law, but I don't know that it is. But which is, you told the client about what happened. You told them something happened that was bad, may have caused them damages. You didn't use the M word. You didn't tell them there was a conflict. That in and of itself was breach of fiduciary duty. That was a concealment. That tolls, even after the representation is over, that continues to toll the statute of limitations. I've heard exactly that argument made, and that's a concern to me. The concern too, which we don't acknowledge, as we said in what came from Orange County, about what it means under a malpractice policy. What it means now, every time a lawyer thinks that they might have made a mistake, if they read COBRAC and they believe these things and they reach a particular conclusion from this opinion, they're going to be constant.
Can you?
Let me just finish. It's just to say constantly may be hyperbolic, but I have concern about what lawyers are going to do if this does take on a life of its own. That they will say every time I make a mistake, regardless of how I think it might impact things, my doubts about it, in order to protect myself against a claim that I breached fiduciary duty, I need to mention the M word. And if I don't, but if I do, I'm going to create a problem with my insurance coverage.
We're not saying they need to say the M word.
Yeah, I know you say that, Kendra,
Yeah.
but
You
other
think it
lawyers
reads
will
that?
in
I don't.
fact take this and argue it exactly that way, as I said, and I've said many times. If there were a malpractice litigation about this, if there were an evidence code section 352 objection to the discussion between the lawyer and the client about that sequence of events, you'll get judges going both ways on whether a jury can hear that.
Just to,
And so I'm not quarreling. You guys think I'm quarreling with this proposition about whether there's a conflict. I'm not.
well, can we,
I just think it ought to be clear as to when there is a conflict. And this opinion does not explore that. It does not explain that to people.
just to focus the discussion, because every time, understandably so, we get into a similar conversation that takes us away. I'm just curious, Matt, not to put you on the spot, but the specific language that you are concerned with, could you please focus our attention on there? And do you have a suggested fix, or is this something that's going to bother you regardless going forward? So we have a suggested fix, let's consider the fix, and then we can move on. But I think it will help the committee just to, let's just focus and keep moving. There are a lot of other opinions to get to. I think this one's really close.
I don't think I
Let's
have anything
address
further
your
to say
specific
about it.
concerns.
I don't think I can begin to redraft it. I think.
But do you, it was there, so there's no language,
Well,
other than, yes, other than not trying to open up a rewrite, but is there a sentence or two that gave you particular concern with this latest revision from Steve, that you had a comment, a suggestion? Does like a revision could fix or address your concern? The broader committee could take that suggestion, and then we could
I think,
vote.
I don't want to speak for Matt, but I mean, what I hear is I think Matt has had an issue with the opinion, continues to.
I agree.
Respectfully has a different view than others. I do think we're going back into old territory. I mean, I know what Matt articulated about whereas reading this to suggest that they have to use the malpractice word. We spent a lot of time talking about that at the last meeting. And I know your view is different than some others, but I mean, we've discussed that. And some people think, Matt says a lawyer could read this and will, and they'll assume they have to say that. Other people think this doesn't say that anywhere, and we just have to get beyond that. And I don't think we're doing anything new here. Not to have people not voice their opinions, but so if
yeah, I think it would require not insignificant. Well, I would like to see. I'd like to see an explanation of this opinion about why the lawyer has a conflict, so that lawyers can readily understand that. In this setting, we theorized about what it is. And Dean came up with one that is, I think, interesting, which is the lawyer may embark upon what's the word I'm looking for? Almost a pilgrimage where we're going to do everything we can to get this cross complaint back in the case because the lawyer's just trying to cover their posterior, whether it makes sense or not, whether it's worthy of the expenditure. And now they're spending the client's money doing that.
Let me add one point to
Yeah.
that, which is it's also the fact that the lawyer, I mean, the whole business of arguing about whether you would need to say something further like, hey, there's a conflict here, there's a possibility that my conduct will be materially limiting. That argument in and of itself, I mean, to a certain extent, at least for some people, could be self-serving on the part of the lawyer. I mean, the mere, the desire not to have to say anything else, in a sense, sort of proves why there's a conflict scenario. And there is a question of judgment, to Steve's point, and I think it's the judgment not only of the lawyer, but it's the client's judgment, and the client's informed judgment. And we're talking about concerns about, do I have to say anything further beyond the facts at this point? I mean, I think you got a conflict. If you're at that point, and you got to tell them the facts, and you made an error, and it may or may not lead to damages, and you're worried about what, if anything else, you have to tell the client, I mean, you got a conflict. Now, the question is, what do you gotta tell them about the conflict and so forth, but I mean, anyway, but I don't wanna beat a dead horse, but
Right, so-
I don't think it's just the, I'm
Yeah.
gonna go run up appeals and all of
Right,
that.
well, I think at page 43. I'm sorry, it's page 44. The lines 286 and thereon, it does, people will read this and say, under these facts, really, the time to file the cross complaint is lapsed. That may cause damage to the client. You now have a conflict and you need to explain to them why you have a conflict. I don't think I don't know if that's always true. I think under these facts, it's clearly debatable about whether you have to take the conversation beyond what I understood you were just outlining, which is, the client says, well, what does this mean? You just told me we lost the cross complaint, it's not in the case. Some clients will say, well, what are you trying to say to me? I'm saying you should talk to an independent lawyer. Well, why? Well, I know what I'd say, okay? But I'm me, and I believe I follow a higher standard, okay? But I don't believe that every attorney should always have to do that every time they have a concern. I think you need
Well, but in
certain.
that scenario, you're clearly under the provision in the new rule that says where a client is asking you for advice or further elaboration.
Well,
with
if
respect
you're
to
asking me
facts in a
whether,
situation where you know you
yeah,
can't.
well, if you're asking me whether you think you have a malpractice claim against me, I can't tell you whether you do or don't. You need to talk to an independent lawyer about that.
And then they say, why? And what do you say? Because we have a conflict.
Yeah.
Yeah.
Yeah, if I agree that part of the conversation needs to occur, then look at it. It's going to seem like a filibuster. I am not intending to do that. But I think that people will always debate whether there was a conflict, where there's a mistake. I mean, we have draft opinions floating around here that I thought about connecting. We have one floating around, and Richard's not here, but about where you lose your cell phone, do you have to tell your client?
That it's malpractice, you do, yeah.
Yeah, so you'd have to tell every client they potentially have a malpractice claim against you if you were to start to connect those dots, and if you had that kind of syllogism going on. I think this just becomes absurd. If you are a litigator, I think it's very destructive of the client relationship for a lawyer sometimes to be overly cautious and tell clients, you need to be concerned about this vis-a-vis your relationship with me. And some clients would lose confidence in their lawyer. It would have a dramatic impact, especially a really sophisticated client. They go, why do you keep telling me you did something wrong when you really don't think so? And a lot of lawyers will go, I don't think I committed malpractice. The client will think I'm a ninny if I say that. That's destructive of my relationship with the client. This will have unintended consequences. Again, I'm not disagreeing with it. I just think it needs to be thought out.
Do you think it's not clear in here that we're talking about only those mistakes that are significant developments? I mean, lawyers are going to make mistakes. Not every single one of them would qualify as a significant development. It sounds like what you're saying is you're worried that lawyers are going to think every time they make a mistake they have to tell.
Every time they make a mistake that potentially could lead to a malpractice claim, some lawyers are going to argue, Kendra, see this chiropractic did. You have a conflict. You need to explain why there is a conflict. Then they'll add this argument. Your failure, I get it. You explain to them what you did wrong. You didn't connect the dots, though. You didn't explain why there's a conflict. That was breach of fiduciary duty. That told the statute of limitations. I have heard that argument made, and I think this will be used potentially for that purpose, and I don't think that's it. I think that's a stretch.
I think that risk is, I don't think, I could be totally wrong on this, but I don't think that this opinion materially changes that risk. That risk is already there. People are already making that argument. And it's very hard to, I think it's, I think Andrew's point is the right one, right? What language would we change? I think it's very, I'm not, I have no pride of authorship here. I'm completely open myself. This is fundamentally Mary's opinion, and all that's good is hers, right? But unless we can come up, unless you, I think we've definitely heard this concern, right?
Yeah.
My feeling is we have 7 or 8 other opinions sitting here waiting for discussion, including some where we have, like Suzanne, we have Suzanne's opinion that she's leaving. My feeling is we should move on unless there's something substantive we can do.
Yeah, what I'd like to do, and I think we've talked about this issue quite a bit, but I'd like to see if there are any other comments to the opinion from anybody else. Not cutting you off, Matt.
Yeah, in fact, I have to say that I would prefer to be cut off.
Yeah, okay, so what I'd like to do is see what other comments exist, if any, and then I think, we may just need to make a decision about this, I think, despite the fact that there may be some differences of view. Yeah, Teresa.
I just think there is, I just want to recommend something substantive, because generally, because I think I agree with the problem that we're going down that hole. And the substantive suggestion I would have is, if we go back maybe at 280, where it says the lawyer may not, or the lawyer should not discuss with clients like 270 something.
285 to 86?
285 to 86. All right. It says in 285 that the lawyer and law firm should not advise the client as to its rights. What I'm suggesting is that instead you begin that sentence with Rule 1.4a does not require that the lawyer and the law firm should advise the client or advise the client as to its rights against the firm, or whether the actions constitute malpractice, and then eliminate everything else.
Eliminate the point that they have a conflict that forbids.
See, what I'm thinking is leading us down rabbit hole is exactly what we've been talking about, is that we're saying that when these facts occur and you explain the facts and the options to the client, that you discharge your duty as to 1.4 B1. And if you can go farther and say, and this means we might have a conflict and you ought to seek other counsel, but I don't think that's what 1.4 requires. If you've got a conflict and you know it, that's a different, that takes you somewhere else, but that's the suggestion.
Okay, but then that requires also that you have to deal with all that other language, Teresa, at 286 to 294.
And that's
right?
what I'm saying. I would eliminate that.
Well, but
takes
that's
us back
the
to
problem.
another place,
But your conclusion that there's no obligation to disclose requires that you ignore all that language, which suggests you do have an obligation.
And
to
I think
disclose.
that's why we were talking about, is there a substantive way that this is the substantive
But
way
you can't
to
say
identify.
Rule 1. You can't reach your conclusion, which is the desired conclusion, which is that 1.4 does not require that you talk about the conflict without reading all that language out of the rule. That's the problem.
Exactly, and that's why.
And so that's why it's not, I don't think it's an available solution
Well,
without being
yeah,
irresponsible.
I just wanted to concretize the point that was being made, is that you don't have to advise a client, and you should not properly advise a client, but you don't have to advise the client that it has what implications it might have for malpractice, or what implications it might have for discipline. You're supposed to advise the client about the facts and about the potential solutions. That's what that rule requires. And I agree that if you start going down the rabbit hole, that every single one of these presents a conflict of interest, then indeed, that's true. Then all of those are true. I'm suggesting that this is one alternative, which concretize the point you're trying to make.
Yeah, I agree with that. I think that now saying it again, that's changed. Can you highlight the language? Yeah, so, yeah. Well, no, I think it's, what this literally, under this fact pattern, when you're cross-complaint, you blew the deadline, hasn't been determined yet that the client any malpractice fees may not be damaged or something else. You need to disclose those facts. I get that, I agree with that, that's the deal case. Next sentence, 285, should not advise the clients to rise and whether the actions, yeah, right. Lawyer will often have a conflict of interest that bars them from advising client on those issues. And you can't tell your client whether they do or don't have a malpractice claim against you. And should advise client to seek other counsel to advise them. Lawyers will say, this opinion informs me that I should tell them, you should go talk to another lawyer about whether you have a malpractice claim against me. I don't. I think that's.
Or should it say, advise client they may seek other counsel to advise?
I thought it used to say concerning the circumstances. Isn't that what we talked about last time? There was some kind of compromise language.
Yeah, it's in, yeah, the compromise was earlier. The compromise was in the discussion section relating to the duty to communicate. And we did make that change. There was the,
It's 119, the red one.
My comment to that language that, you know, Teresa's positing be removed, I think would be a mistake, because I think that is the ethical issue. The ethical issue here, and not about, you know, risk management or anything, the ethical issue here is that you have you are not able to advise the client as to whether they have a claim against you, and that is a limitation on your representation. And that's what you need to tell the client. And that's what's supported now expressly. I mean, I agree the new rules really do make it more express what we have concluded already just through case law, but now it's expressed. That is the ethical dilemma. And that's what you need to say. I am not able, I am limited in my ability to advise you whether or not you have a claim against me. And so I think it would be a mistake to take that out. And on the flip side, to Matt's point, I also don't read it as requiring you to say, you know, you have a claim, or, you know, the M word or anything like that. What you're advising them on is your inability to advise them, which is quite different. I think it's an important language, and really does support the opinion's overall conclusion, because that new rule has very helpful language in it.
One of the things I think that works for me, Suzanne, and I think it captures it. One of the things we need to leave into the opinion is enough room for an attorney to be incentivized to fix it if they can, and to discuss if indeed there's been a mistake made. Enough room in there to incentivize an attorney to fix it if they can, with the client's full understanding of what the implications are. And if we're able to capture that in the rule, I think that certainly satisfies my concern.
I think maybe we should see where we're at with this. I mean, I can't tell. I mean, if there's a motion that if someone's prepared to make a motion on this as it's drafted, or not, and if so, how that's going to shake out amongst the group.
Can I ask a specific? I totally agree. We need to move, but I do have a specific question regarding substance that has just recently been raised, and that is, should the language on lines 286 to 287 mirror the language on 118 to 119 so the opinion's consistent? And I think that's worthy of, we don't need to get into this hypothetical debate, talk about hypotheticals that aren't in the facts that we're dealing with. Just simple question.
What were the lines?
So 118 to 119 says attorneys should also consider advising the client to consult, should also consider advising the client to consult independent counsel concerning the circumstances. And then you get way more specific in 286 and 287. I don't know if that's because what I just read in 118, 119 is a general consideration of what the rules and obligations are, and 286 and 87 is a specific analysis of the facts of this.
No, I think that's
Hypothetical?
right, there's a softness
Should
in
we-
the first one and a much.
Exactly.
Well, and that was the compromise.
Right.
So should we mirror that language on 86 and 87?
Yes.
I think that would be fine.
Yeah.
Yeah,
Okay.
trying to raise that as well, I think that's true.
Oh, okay.
So should consider,
So if we go,
Consider
advising the client.
so I'm back on 85.
So
Lawyer and law firm
Advise the client to consult.
286 and 287.
have a conflict of interest that bars them from advising the client on those issues, and
Should consider.
Should consider advising.
yes.
I think we could strike out since they clearly have a conflict. It's kind of aggressive.
Yes.
Well, we already had struck that.
Oh, I'm sorry. Not in my version.
No, but
Yeah, earlier this morning.
I think maybe we only needed to add like 2
Yeah.
words there.
Oh, where?
And, well,
Sorry, I'm just.
yeah, I think you maybe overcomplicated things.
Okay.
That's all.
Okay, so
I think it should just be the original thing with just, and should also consider advising
Yeah.
client.
that's what I, yeah.
It's not, I don't think there's an also.
Yeah, right.
Take the also.
Yeah,
Right.
yeah.
Yeah. We want to say
To advise them,
on them.
period.
I think we need that to advise it.
Wait a second, no. I want to leave it to
Oh.
advise.
You just clean it up, because this is getting very confusing.
On those issues, what do we say in the one that?
Concerning the
Concerning the
circumstances.
circumstances.
Yeah.
I
To
think,
advise them
go
concerning
back,
the
I think go right back to that language, Andrew, that's a very
At the end of the
constructive
sentence.
suggestion.
Concerning the circumstances. So I'm up on combination with bars and.
Or just say to advise, yeah.
Well, that's fine.
Yeah, that mirrors the other side.
Other counsel or?
We want to say
independent
the
counsel? I
client,
agree.
we don't know that the
Same.
client is a them, do we?
Independent
I
counsel.
think independent as well.
I don't.
Okay.
Other, I
Other?
think is fine.
Just to be the same, you want to say consult instead of see.
Yeah,
Advising client to consult other counsel. We do say independent.
Oh, we do?
Yeah.
Well, then maybe we should stick with that.
I mean, if
I
you
like
wanted
this
to
one.
mirror.
Okay, independent.
I agree.
Yeah. Okay.
Okay, and then footnote 12 is
You
still
know,
relevant?
It
That's
just
a
say
question.
concerning the, consult independent counsel
I think that's right.
concerning the circumstances.
Yeah, concerning the
You
circumstances.
don't need that to advise them
Yeah.
concerning the issue.
Yeah.
Yes, better.
Even.
Okay.
I like it, Bob. like
I
it
do
all.
too, I agree, I was asking the question, just
Yeah, I
want to make
think
sure.
it's a good one.
Okay. Anything else?
How about a vote?
Yeah.
Justin.
Yeah, Justin.
I won't rehash the views and what my view is, I just want to go through a few linguistic things here, language-wise. In page 9, lines 292 to 294, I didn't quite understand the last sentence that starts "and of course." In the first clause, it's talking about the lawyer and law firm's sort of discretion. They've decided to seek informed consent. And then in the second clause, it's talking about disclosures being required. And so I didn't quite understand the connection there. You know, why does a lawyer have discretion to seek informed consent? Is it more that when the situation arises, the lawyer needs informed consent?
Can I try?
I just
Try
wasn't
that
sure.
question. It's a good question. And I think it's one that a lot of, I've been talking to people, and so I think the answer is that there's a difference between your obligation right, to communicate essentially that you can't talk to somebody about the malpractice claim, right, or about the possibility of a malpractice claim or rights against your firm, right, and what you have to say if you want to continue the representation. They're independent questions, right? If you want to continue the representation, right, then you have an informed consent obligation under 1.7, right? The first conflict disclosure is essentially, I have a conflict, it's non-waivable, I just cannot do this, right? I cannot talk to you about a claim against my firm because there's no way that you could ever consent to my advising you on that, right? And then there's the second question, which is, I may be able to continue to represent you for all the reasons that Teresa and Matt have been talking about so helpfully, right? There may be a lot of ways that I can still help you, including that I'm the person who knows the most about this case, right? And you've may have paid me a lot of money to get smart about it. So there's, when you say I want to go forward under the rules, that triggers an even more rigorous set of disclosure obligations, right?
So the pivot point is deciding you want to continue.
Yeah.
So
If you decide you don't want to continue, you don't have to get.
So I think that element's sort of
consent.
missing here.
It's a
You know,
little confusing, yeah.
Yeah.
Okay, how would you change it?
Well, I think the element that you just described is the lawyer may make a decision that he or she doesn't want to or cannot continue the representation in. We don't discuss that element here. So if that's kind of what this is talking about, the lawyer's decision whether to continue or to, I guess, withdraw, maybe we need to make that more clear.
So is it something like end of course of lawyer and law firm have decided to continue the representation and therefore must get client's informed consent and then go on such disclosures policy?
If lawyer and law firm would like to continue the representation, they must seek client's informed consent and make required disclosures.
Actually, I would want to suggest here that maybe this is a point where we've all kind of a little lost the point of this opinion, which isn't really about what happens after you decide you have conflict. And maybe we don't actually, that sentence that starts "and of course" is actually an opinion in itself, right? That's so complicated, that question of what you need to do
Yeah.
if you've made a mistake and then you're going to talk to the client about continuing to represent you. And I'm not sure we need it here. I don't think the opinion is incomplete without it.
I mean, it is in the opinion elsewhere, where it's just referenced, like, once you reach that point, then you have to decide if there's a material limitation that you can or can't continue. And that's
different.
probably enough, right?
That's different than what you have to say once you've made that decision. You want to continue.
Yeah. The
Right.
sentence
So
here.
it's already in there, so we probably don't necessarily need it here again.
Well, the only,
In this way.
I don't have a problem with, if you'd like to drop it here, that seems fine. We're not, it's not, we could also drop the "and of course" and move the whole thing, if lawyer and law firm, move it to a footnote. So it can come at the end of two, right? So you put it at the end, and I'm just suggesting, don't do anything.
Oh, I
Right.
can undo it.
But, okay, but the idea would be to put a footnote right after the word "case," right, and then drop the "and of course" line, yeah, and then drop that.
What would happen if we took it out of the hypothetical, like if it was not capital L lawyer and stuff, and just so we're just generally flagging for people. I'm not sure how long we could go. Maybe if you can go back on the footnote. If a lawyer and law firm decide to seek a client's, it's very hard, client's
Decide to continue representation.
after after a conflict has arisen. I'm just wondering if that would be better because it's not consisting of these facts.
Yeah.
If a lawyer.
So isn't it, if a lawyer has decided that
Yeah, you just say, if a lawyer
can
has.
continue representation consistent with 1.7.
You can drop in law firm, because we're trying to abstract from the facts of the case now.
If a lawyer decides,
Or would like.
But it's not just with like, I think, because they still have to comply with
D.
1.7, with D.
right, they decide they can,
That they can,
able.
that it would be permitted or something, with informed written
Oh,
consent.
that's a better word.
Or determines to continue.
Determines.
Is
Yep, yep.
allowed.
Right.
Yeah, that's better.
Yeah, something like that.
Is able to?
Lot of words. Lot of words
There you
go,
go.
what's
How about the
the,
lawyer is able to? If the lawyer is able to.
Lawyers continue.
They cannot just.
Drew, what was your suggested language?
The lawyer determines.
Continued representation is
Okay, the lawyer determines
permissible, yeah,
that
with informed consent.
continued
Representation is permissible.
It's permissible under Rule 1.7.
Right.
Should we say with informed consent?
Yeah.
Informed written consent.
And then just such disclosures.
Such disclosures is a little unclear now, isn't it? The disclosures the lawyer must make, or the lawyer must make such disclosures as required by.
Maybe we should just drop it.
Let's just drop
Let's
it.
just drop it. I don't think it's worth trying to wordsmith it.
Intellectually,
It's
you're right,
wordsmith
it's
it. No,
correct,
I-
but we're
I-
not
I
gonna
know
do it
it's-
justice in a sense.
It's, no, what I'm trying to,
cause more
what I'm
harm.
trying to head off, because most times the lawyer will want to continue representation, right? And so I'm just making the point that, I'm trying to make the point that hair splitting about what you can do under, if you're not continuing representation,
It's an aside.
is gonna make not much difference. But it doesn't need to be in there.
Okay.
All right, we said a couple other.
Okay.
Just globally reviewing these, I saw that when we were making the rule changes from the current to the new, oftentimes we are inconsistent. Sometimes we lowercase the R, sometimes we
They
uppercase
all
the
should
R
be,
rule. So I
they
just
all
want to
should
make
be
a comment.
lowercase.
Yeah, that we should just universally make them the same.
Oh, yeah, I'll do that.
Perfect. And then also stylistically, I just don't recall offhand. I noticed here it doesn't trouble me, but we're sometimes informal in saying, we feel this, we think this, we conclude that. I don't know how the committee feels about that in a formal opinion. It doesn't trouble me, but I just want to raise it if we feel we need to sort of tweak that language to take out the we. That's just minor style stuff. On line 306, and I apologize if this is something that we did talk about. I'm not trying to rehash something if we've already reached a conclusion, but we use the word claim here. Once a law firm knows that the client has a potential claim, as we've discussed before with respect to the word claim, I think it has certain meanings. It can be a loaded term. And I'm wondering if that's also as precise as we can be there. Is it that the law firm has to decide that the client has a potential claim, or is it just that the law firm has to decide, that there might have been an act of malpractice, to use the language of Beal Bank? Is there even a distinction between those two?
Or just a conflict.
So what I'm raising,
There's a conflict.
yeah, what I'm raising there, I'm not sure that potential claim is the most precise or accurate phrase here, and also given that claim has certain connotations and meanings, I wonder if we would want to choose a different way of describing whatever we're trying to convey here.
Is the language used elsewhere, something like giving rise to a potential claim or something
Yeah,
like
if
that?
you look at 101 or 102.
Could also say, once the, this language is holdover, right? This is not new language. We voted this out already. But if you were going to change it, why not just knows that, or just that it has made a significant error, right? Or is aware that it has made a significant error.
Well, you may make a significant error if it's not malpractice.
But that's,
And we're talking about whether representation should continue. Right?
yeah, I may,
So it's a conflict.
It's a
question,
conflict.
Like you said, it's a consideration of whether there's a conflict.
Which is what we were just talking about before.
Well, but you have to put it in a context too. Here we are talking about this law firm. I guess it doesn't bother me that much because we say earlier, I mean, like on 101, 102, we're saying the duty of communication requires, among other things, the attorney to disclose material facts potentially giving rise to any legal malpractice claim against the attorney. I mean, we're saying under these facts, we have that, and there's a disclosure, obligation at a certain point, and so referencing that, I mean, I understand the sensitivity of the word claim, but I mean, we've talked about the fact that these facts could give rise to a legal malpractice claim, and I don't know how we don't. I mean, that's part of the facts, and it's part of what drives the analysis about, whether there's a conflict and what kind of disclosure has to be made. To me, it's not, I don't see it as particularly inconsistent with what's in the earlier part of the opinion, but if there's some way to...
Maybe it's just my sentiments about other aspects of the opinion that have caused me to focus on that language here. And then finally, I'm wondering, given the direction that opinion is taken, where I think it does go beyond just discussing, this exchange that happens either with in-house or outside counsel when there's an ethical question, and goes really, I think, to focus on the question of what obligations exist to inform a client of some kind of significant development. Do we feel that the, or error, or whatever we want to call it, do we feel that the issue, as we describe it, is broad enough? I don't know that the issue section of this has been revised since. I look at the issue versus the digest, for instance, and the digest in the second part of it discusses what I think, at least for me, becomes much of the thrust of this opinion, which is what the lawyer has to convey to the client, regardless of whether the lawyer has consulted with in-house or outside counsel, when there is some kind of significant development or material error that has to be communicated. The issue itself, though, doesn't necessarily convey that. When I read it, and what I thought this opinion would be about in just reading the issue is the act of communicating with in-house counsel, or the act of communicating with outside counsel. But there's another important aspect of this opinion, which is the act of communicating with the client. So for me, if one just reads the issue, one might not know that this opinion goes into some depth on that latter issue of communication.
Well, this is not a complete answer, aside from the fact of not wanting to redraft the issue, just as a matter of administrative convenience. But I think that, we've been focused heavily and understandably on the downside of including in here all this stuff about the duty to disclose, right? As if it's somehow an add-on to the opinion. But there's an important sense in which it's not really an add-on. It's trying to set up the circumstances under which you can be confident, right, that you are in a good place in terms of your consultation with counsel, and in terms particularly of your consultation with in-house counsel, right? So it's like the counterbalance And, I don't want to be ungenerous to anyone here in describing some of the objections to this opinion as coming from a defense-oriented perspective. But it would be well for everyone who has a defense-oriented perspective here to focus on the fact that the fundamental message of this case of this opinion is defense-oriented. The goal is to take away from the people who've been saying that it is conflict of interest territory, right, to consult your in-house counsel, and that it vitiates the privilege, right, or that it gives rise to a breach of fiduciary, and to take that territory back, right? And part of taking that territory back is spelling out how you deal ethically with this problem of a mistake. And so, so the digest says what ethical obligations arise, and then the issue, but then the digest says, right, once a lawyer becomes aware that he or she has committed an error, the lawyer ethically may seek legal advice, but must comply with the rules governing disclosure to clients and conflicts. So we're giving a nuanced answer to the question, right, that recognizes that the lawyer needs to be doing both sides. They can certainly seek advice, right, and indeed the fact of their obligations is precisely, to the client, is precisely what means that they need advice, because this stuff is complicated. So, I don't know. So I'm just saying, I think that we've added, that maybe this is overstating it, but I think that the issue in the digest, the digest deals with your question in a way.
No, I understand that. I think I acknowledge that. I'm just wondering if anyone else is troubled by maybe the lack of parallelism between the issue and the digest, and I'm not hearing anyone who is troubled.
I think it's a good point.
What would you say?
I would revise the issue to include reference to the fact that the opinion is addressing the communication that needs to occur between lawyer and client.
Isn't that encapsulated with ethical obligations that arise?
Not if you just read that.
I mean,
great, in the digest,
obligations-
obviously it's clear, but
But one of
We
my,
also don't say
one of my concerns, I think it's sort of an overarching,
duty of loyalty.
issue with respect to this opinion is that I don't think it says what some people says it does. So, I think the opinion goes through great lengths to stop short at telling you what you need to do once you've got that conflict. And the space that's being staked out here is the part, can you figure it out? And are you in a safe space to do that? And when you're there, once you're there, then you've got to seriously consider whether you can continue the representation. And that's it. And then what disclosures are going to be needed here, the rules you're going to want to look at, and that's it. Like, we're trying very hard not to go into that space of, okay, what do you have to say and what do you have to do at that point of conflict? And when you look at, the opinion, especially at pages, at lines like 249 to 250, we state unequivocally, because we conclude that the act of seeking advice regarding a lawyer's ethical obligations does not create a conflict, we don't believe in imputation applies. So we're deliberately and repeatedly sort of making clear we are talking about the place before the conflict and what you have to do at the point of conflict. Here are the rules you're going to want to look at, but that's it. We're not going there. So I think it would be a mistake to suggest that the issue that we're actually trying to tackle that, because if we were, this would be incomplete, right? This would be an incomplete treatment of that issue. But I think it's a very complete treatment of that prior territory, which was the essence of what this opinion was really conceived to do, was to stake out that space and let lawyers know that they can ethically seek this kind of advice without having to worry about, you're going to be accused of, well, they might be accused of anything, but, that you can ethically go there and not have to worry about it. So I don't think that the opinion really does try to delve into what specifically you have to say and all of that. It's telling you what the rules are.
it delves into the fact that you have to say something. That's an important
That's
aspect
your
of this.
ethical obligation.
Right.
I mean, I do think the committee on the whole, you know, the majority of the committee projects, you do have to communicate something.
Okay, so, all right. I
As
was just
part of your
wondering, I
ethical
just wanted to know if people thought that it needed to be revised. It sounds like the majority don't think it does. So, yeah.
Do we,
What were you thinking, like, what would you put in there?
Just as I described before, to reference the fact that this opinion is addressing the fact that, is addressing the issue that a lawyer needs to communicate with the client. It's not just about the exchange between the lawyer and his or her outside counsel and the lawyer and his or her inside counsel. It goes into this portion of the what's referenced in the digest in the second in the second aspect of that, where the fact that the lawyer needs to communicate with the client and sort of the framework for that discussion. For me, as I read this opinion, whether I agree with it or not, that last aspect is a very important part of the opinion. It just seems to me that the issue section doesn't capture that. If people disagree, I don't feel strongly about it. I'm just telling you about it.
I think, I don't actually feel, I think it's a fair point.
What about, what ethical obligations arise when lawyers in a law firm make an error and want to consult with outside counsel?
So it's two things, because there is still such as lawyers' ethical compliance, so I agree.
Well, the problem with that is,
Or,
remember,
I mean,
we have
shouldn't it
multiple
be-
hypotheticals. There isn't an error in the first.
Concerning management of the firm's representation of a current client, including?
I mean, for me, it seems like the question you're raising, Justin, is do we want to be more specific in the issue statement as to this one?
For me, that's the first thing somebody's going to read about this opinion. What's it about, right?
Right.
At least for me, when I first read the issue, I thought it was just going to be about when a lawyer thinks they made a mistake and they want to consult with their general counsel or their outside counsel. And then when you read it, it addresses other aspects of this. And then one of the, obviously, as we've been discussing, one of those important aspects, related to the ethical obligations grant, is what the lawyer then has to say to the client, which I think is a very significant portion of this opinion. And at least, as a potential reader of this, when I look at the issue, or when I think of what a potential reader might think, they might not get the fact, on my concerns, they might not read on, that this goes into much more than what, at least when I read the issue, contemplated. That's all.
They'd have to not read the digest.
They'd have to not read the digest.
I think what the opinion is concluding is that the ethical obligations are, among other things, communicating with the client. So I don't necessarily think that that's the issue that it's grappling with, what do you have to say to the client? What it's concluding is that you do have to communicate something. But I see what you mean by, maybe it's, instead of saying such as, maybe it's, and you consult regarding an error, of the firm, to make it more clear that we're talking about what your obligations are, ethical obligations are, when you consult about an error. I mean, I think it's in there, but it could be more explicit.
So, I'm sorry, what's the suggested revision?
I think it's embodied in the first sentence, it's just not specific, and I think Justin's point is it's a big
How about-
it seems like a big deal, shouldn't we be more specific and highlight that? That's one of the ethical obligations that arises, and we discuss it, and it's a big deal, and so should that be more pointedly raised in the statement of the issue? Because if someone just reads the issue statement, they won't get that won't be highlighted.
Right, so I'm sorry, how would we capture it?
I'm concerned that, that's just my view, but I share what Suzanne said, which is I think we're trying to walk a pretty specific line, and I'd like to think that people will read the issue and the digest together. I understand,
No, I get it. I mean, look.
And I'm concerned about trying to highlight something within the issue that in some ways, I know we're saying it's a big deal, and we talked a lot about it, but we're also saying it's an issue that's kind of away from what it was trying to be done originally, et cetera, so.
And I don't think there's actually that much of the opinion that we've talked about that portion a lot, but in terms of content, there's actually not that much in here.
Well, that might be true, but in terms of the impact and effect, I think it's a very important aspect of this. And I don't think that the opinion is intending or trying to be in any way disingenuous by not highlighting that as the issue. But just it seems to me that given the importance of what we're saying with respect to the communication between the lawyer and client, to sort of not address it as part of the issue of the opinion and then put it in the digest and then put it in terms of the discussion in the opinion. It just, something about it doesn't sit well with me. I'm just telling you what my feeling is. I understand I'm in the minority here, but I wanted to raise it in case anyone else.
How do you think we should change it?
I think that we should be more explicit in the issue section, that what we're talking about is not just the loyalty aspects that might come up when a lawyer communicates with in-house or outside counsel, but we're also talking about the communication duty to the client. And there's no reference to client in the issue, and I don't know, for me,
Well,
that ends up
what
being-
if you said, what ethical obligations to the client arise when lawyers in a law firm?
Because I think that's all the opinion's talking about, are your ethical obligations.
Well,
I don't know.
how about this, and maybe this isn't enough, Justin, but how about this? What if you said, looking at line 7, change the word issues, right? Outside matter concerning issues related to the firm's representation of a current client. And then it says such as, what if you said, including the lawyer's ethical obligations in connection with a possible error by the law firm?
Or just including the duty to communicate with the client about the possible error. I guess that's maybe where, I mean, I agree, I see where you're going, and I think that's a good, improvement, and I think it is in that such as clause that we're sort of, yeah, we're missing that key analysis of the opinion as one example in the such as clause there, that we are talking about the duty to communicate to the client.
I really think you muddy the words.
That makes
All right.
I guess it's now,
Well,
it
I mean,
might be narrower than it would be otherwise.
Okay.
It might just, it might actually narrow it unduly. Okay.
To me, the digest is pretty generic, which is probably okay. So what did we do with the 1.7 language that was going to go to a footnote? Did we not? Can we all look at that again? Just
Gone,
Very
gone,
troubled by
gone.
that section.
we got gone.
287.
Okay, stop.
That 293 to 295, gone.
But this, at 288, as noted above, Rule 1.4B4, requires the lawyer to explain the ethical limitations that prevent them from giving such advice when he or she knows the client expects it. Right.
That's straight up.
That's what the new rule says.
Right, that's 1.4B. Right.
Is it B4? A4?
It's 1.4A4. Sorry.
No, I think we changed it earlier, but my computer died, I might have not saved it.
It's 1.4B, there's no 4 to B.
Is it 1.4, is it 1.4A4?
Right.
Yeah, it's either
Yeah,
A4 or
we
B,
quoted-
but
quoted
it's not.
right to page 4. A4.
Right. And that requires knowledge. That's what A4 says. Right. The word knows is
Right.
used.
Right.
While we're here, I have a really minor point. That prevent her from giving such advice when she knows that the client expects it. You can't say her and then he or she. Kind of just a point.
Right. So 1.4A4, it does say, advise the client, that's what the rule says, it used the word knows, which is close to actual knowledge, by the way. But then the next sentence, I think is gratuitous, and it's just, I don't think that's true, and I think that gets back to the central debate that we've been having. Whether or not the lawyer knows the client has that expectation, in other words, not required by 1.4A4, we think that such advice would normally be required by A3. And what advice is that?
You can't advise the client on the conflict. Right,
Okay.
I'm kind of a,
I would like to delete that.
I'm okay with that, actually. I think the significant development is the error. I don't think that, I mean, I think you could argue it both ways, whether A3 would require a due disclosure of your inability to advise.
I don't have a commitment to any particular sentence, but I think the opinion gets misleading. If you take out, most cases, the lawyer's going to continue representation, right?
Yep.
They're going to have to say this if they continue representation.
That I can't
Right.
advise you on much of the claim against me.
Yeah, right. And that I have a conflict in doing so,
Yeah.
right? So so you guys said, take that out, that's gratuitous, but that's the case, that's the most important likely scenario, right? So we've now eliminated the obvious point that in most situations you're going to have to say this because you want to continue to represent them, right? And we're chopping away, we're saying, well, if you don't know, right, that they expect the advice, you don't have to tell them, right? And then we take out this language, and all of a sudden, we're not really saying the truth any longer.
Well, but
Which the truth is that, in fact, it's a very, very dangerous thing to do, not to explain
But when
this.
you have a line 285 and 287 that says there's conflict.
And Matt, you and I have had this conversation before. I think it would be I think it's likely malpractice if you don't tell the client that they have to say that. If you're an ethics advisor and you don't tell them that they have to say that in that circumstance, I think you're pretty much walking them off a cliff. And I don't think as a committee that purports to give ethics advice to the state bar, to the lawyers all over the state, we should be doing that. The opinion starts to get misleading.
I think the opinion, I choose not to argue whether you're right or not. I just want to point out from
In fact.
From a clarity standpoint, you read 285 to 287, you say, I should consider advising them. Okay, that means I don't necessarily have to read on. If I know they expect that I'm going to be giving them advice on that, I better explain that to them. If I know, and I'll go look up the definition of the word know in the new rules, and I see it's pretty close to actual knowledge. But then it says, whether or not they have that expectation, you should still give that advice.
Ordinarily.
Because of A3.
I think that's contradictory. I think that you already said that that's
Well,
not necessarily
in that-
mandatory.
In that case, we should say the lawyer should also consider whether it's obligated under A3.
Okay.
Uh,
I like that.
I thought the qualifying language was just on whether or not you would consider telling the client to consult independent counsel.
Right, that is where it is. And then after that, we go into fill in the authority for that concept, which is A4 and A3.
A4, no
And
one
maybe A1.
disputes,
A1.
but the question's being raised as to saying.
I think consider is fine.
So what's such advice?
I just want to keep it in there
Right.
because I think it's a real exposure issue.
Right.
I think, in fact, if you gave that to any court, they would say, you should have said that. I can't imagine.
I definitely disagree with you.
It doesn't matter what you guys.
But if we
It doesn't
say,
matter.
no, it doesn't, but if we say should consider, that's fine.
Yeah.
That's a statesmanlike solution.
No, it's that there's an ethical limitation on giving them advice.
So where it says, we think that such advice would normally be
Yeah,
required.
that's-
What's the such advice?
That you can't advise. The limitation.
The inability.
The limitation.
That's the
Oh, we think
limitation.
that the limitation.
It's basically what, so 1.4A4 clearly says that. You got to advise the limitation when you know that the client expects that advice. And the next is saying under 1.3 or 1.4A3, you may have an obligation just under A3.
Right.
Or you should consider.
That the lawyer should consider.
Yeah, and I'm okay with
Yeah,
softening it to
that's fine.
consider.
Again, I think if you'll have a litigation argument that's a doozy, because 1.4A4 says you only have to advise the client when you know they expect advice on a particular matter.
Now, Matt, we're talking about a lawyer reading this opinion. Do you think a lawyer reading this opinion should know that they should consider whether that argument is available against them?
I think a lawyer reading this opinion should know whether or not these facts truly do rise to the level that's under 1.7, which is
It's
quite
really- it's
significant.
been-
How would we
Yeah.
change this sentence if we're going to soften it?
I would just delete it, because I think it's,
I know, but there's a.
I think it's rulemaking. I think it's inconsistent with what happened in 1.4A4 that requires knowledge, and now it says, but maybe you should do it anyway.
Okay, Matt, this is getting to make, this is a little, I know I'm feeling a little,
Don't.
I'm gonna feel a little crazy
Don't.
and you, because
Okay,
you're making me a
Amy's
little
got a
crazy.
suggested fix, so
Yeah,
let's
let's
go.
let's focus.
Let's
Amy.
just see what it would look like.
In addition, look, I think we could strike out the first clause, about whether or not the knowledge exists. Because I think it just, in addition, the lawyer should consider whether such advice is required under, Rule 1.4A3.
Yes.
In addition, the lawyer should consider,
Lawyer,
lawyer, whether, what did you say, such advice?
Such advice
Is required.
under rule, yeah, take out the would, yeah.
Period after A3.
Now leave the rest of
Okay.
it.
Well,
Because I think she might have to go back and.
there's significant development, as you answered your question.
No, it's what you have to say. Well, we've already said it's smatter.
Well, what's the if? Remember, there's two developments, right? There's an error and then there's your limitation. And is your limitation a significant development? I think we could argue about that.
Right, but I thought the context of this was.
No, this is all about the limitation. Right, and we might want to say that. Where are we?
Well,
That's my point. You're saying
Yeah.
this significant,
Right.
you're saying it's arguable, but then we're stating it as if it's determined.
So, but if
Yes,
it's,
you're right,
if
that is
it's, come
tautological.
on.
So wait, just wait. All right, so we should just say the lawyer should consider whether, her inability to advise. No, don't do this yet, maybe. Why don't we take a break and I'll fix this.
That's a great idea.
Break, yeah, break,
Plus lunches.
right,
All right, let's break then.
okay.
What time are we coming back? We gotta make an announcement for the clamoring public.
I'm still there,
I
did they
want
hear that?
David Carr.
David and Eric, are you guys still on the phone?
Good, I'm glad. I don't want this to be too much exposure.
Yeah, Eric signed off the WebEx,
Well,
so.
it's just,
1:15?
It's not always like
Oh, we'll be
this.
back at 1:15.
All right.
are we off record?
Hang on.
It's always
Tape
like
done?
this.
Joe, we got some.
It
always
was just
something.
fun to go to these shows, like it's just such a different experience than, and when,
But
like
once
that.
you get to the
Yeah,
year,
it's like just
Then
like
it
it's
became
like,
easier to
you know,
bring
right,
over
like
after
how
they
people
were
have
like,
to
Drew,
Drew,
some work.
Yeah,
Drew?
yeah,
Drew, okay.
Okay, we're live.
Yes.
Okay, we're back on. You're dialing in. Sarah?
Sorry, you may have been. Thank you. You are the first participant. To mute your line, press *6. To unmute, press #6.
All right, so we left at the break on 12.0005, and I think there was going to be an effort to edit some language over the break.
Yes, it's been done. So it's just the final sentence there, and I made 2 changes. No, so, all right. So it used to say lawyers should consider whether such advice is required, but it'll make it easier if I just talk through it, like nobody does, yeah. But the last sentence used the word to explain, so I keyed off that, and such explanation is required. And then Steve and I had a conversation about the end, which had said to ensure that the client is reasonably informed about this significant development. And it turned out, Drew, you were making the point to me that if it's a significant development, then it always has to be disclosed under A3, so it seemed a bit tautological. But what Steve was saying, which hadn't been clear to me, is that the significant development is the error that in the case, not the limitation. So I tried to make that clear by saying the consequences of this significant development in the case. So anyway, those are the changes.
And to be clear, the kind of case that I had in mind, and which I think that Amy's language captures much better, is the kind of case where the lawyer doesn't know in the strong sense, right, that the client doesn't understand the limitation. So it is the case where the client says, explain this to me. Right? It's the case, which is probably much more common in certain fields of law than in others, right? Where in fact, the lawyer doesn't, the client doesn't even know to ask that question. Right? And in that situation, it seems to me what we're trying to do with this sentence, especially as Amy has revised it, is to make clear that the lawyer ought not to assume that simply because the client hasn't expressed an interest, right, in having the lawyer's advice on this question, the client or the lawyer ought not to assume that a court is later going, or a disciplinary agency is later going to say that they shouldn't have thought about that question, right, and perhaps said something to an unsophisticated client in this circumstance. If we don't alert, and so it's alerting them to that risk in a way, without taking a position.
Okay. So any reactions to that? The rest of the group? So I think we should see where we're at now. We're in a position where there is a desire for anyone to make a motion. We obviously have, some differences of view. But I think we should determine that. So I'll just ask the question, is there anybody who wants to make a motion?
I would move to accept the opinion or to accept the opinion as amended.
Okay. Is there a second?
I think we need to be specific with respect to accept, and because this is going to have to go up for public comment a third time. I apologize to everyone, but most significantly, and I hope the room can appreciate, just the simple transition to the new rules requires. And it's going to be the case for the next two other opinions that I've been on for public comment as well. I was scrambling before to count as many different ways I could to see if a 45-day public comment would get the opinion back before the October 19th meeting. That's not possible. So you're gonna need, I would recommend a 60-day public comment, which is what we typically do on additional public comment periods. That will be plenty of time for the December 7th meeting. There is a Board of Trustees meeting at the end of December. However, it's only held by conference call. I have to check to see if they would approve an opinion at that type of meeting. I can't promise that they would. There is an actual in-person board meeting in November, which I really wanted us to get to. I'm not sure that that's going to be possible. All that to say, it'd be great if we could publish opinion in this calendar year, and we can't get it back before the October 19th meeting. So I think, considering all those factors, I would recommend a 60-day public comment period. Allows for local county bars to typically have trouble reviewing public opinions out for public comment in less than 60 days to review these most recent revisions, and gets it back in plenty of time for you to consider them for December 7th. So I would a friendly amendment to approve for a 60-day additional 60-day public comment period circulation.
Well, I mean, I guess my reaction
friendly amendment
is to defer to the, you guys on what the appropriate period is. I don't have a problem with 60 versus 45. That sounds.
So this would be simply a vote on whether it should go off for public comment.
Yes.
I meant to say earlier that despite all the debate here, I mean, if it does go out, it's clear, it's been clear from the administration that it's going to have to go out for public comment. So
Correct.
we'll have an opportunity to see what the reaction is. Okay, so there's a motion with that clarification.
A second.
Ready to vote? I'm just gonna check, is Eric on the phone?
Eric, are you there?
Okay.
Not there.
All right, ready? Andrew Dilworth,
Yes.
Amy Bonzi,
Yes.
Kendra Best,
Yes.
Stephen Bundy,
Yes.
Eric Dykes, Justin Fields,
This is just for it to go out to public comment?
Correct.
Yes.
Matthew Hodel,
Yes.
Joel Osment, Marlo Richardson, Tina Roche.
Yes.
Teresa Schmidt,
Yes.
Lush Policy, Richard Solomon, Steven Sparta, Marshall Whitney. Thank you.
That's kind of a lukewarm.
I
For
just-
those of you who've been here for other opinions that have been voted out, it's usually a much more harmony.
There's usually confetti that drops from the
Yeah,
ceiling.
yeah.
But it's usually not the third time.
That's the next one. That was a critique back
Oh,
Yeah.
yeah.
No one has.
there. Measure strength.
Okay. All right, so I think for the next opinion, we should do 14-003. Suzanne's the lead on this opinion. This is the settling before withdrawal.
Yes.
And Suzanne, you want to just quickly remind people where we were at after the last meeting on this?
Sure. So after the last meeting, one of the key pieces that had been a change from the prior draft and then what we've discussed was the piece around whether or not you can settle for monetary settlement as opposed to just a release. And as the consensus among the group was, yes, you can, but that we needed to explain that a little bit more clearly. And Steve had some, really good suggestions around that language. So the most significant changes have been to the last section there where we talk about what the lawyer can do when negotiating a settlement, having concluded that under these facts, the attorney probably can negotiate the settlement. And also, we took out references to the defense. There was some public comment about whether, does this opinion apply to defenses that lack merit as well? And we just decided, no, it doesn't. We're not dealing with that. So wherever there was references to the rule that talks about a non-meritorious defense, I tried to take it out. And then the final analysis, really the idea of it was to talk about what are the attorney's obligations when negotiating a settlement. That would arguably apply regardless of whether they're in this withdrawal situation or not, like you can't make affirmative misrepresentation, some other things. And then talk about, this situation where there's information that should have been disclosed, but that was not, and that was required to be disclosed either under discovery obligations or other obligations. And we ultimately conclude that if you can comply with all of that and still get a settlement that includes monetary recovery, you can do it. But under a lot of circumstances, if you comply with all that, you probably won't be able to. But that as long as you're not dealing on concealed information, basically, you can do it. And really helpful to that analysis were the new rules, because there are new rules that expressly state that lawyers can't fail to disclose information that's required to be disclosed under discovery obligations or otherwise. And so that's the other thing we did, was to update this to refer to the new rules, which for the most part were the same as the other ones, but there's a few more that apply. So it's actually, if anything, the new rules that make those conclusions that we had already reached.
And I should have mentioned, there are some hard copies of this, if there's anybody who hasn't had a chance to look at it yet. It was circulated yesterday, so might just pass them around in case.
I apologize, it doesn't have line numbers. Lauren, the one circulating, because I was in the office.
So,
Yep.
so the subcommittee on this is Amy, Joel, and myself. Joel's not here. I have just a couple of minor comments. Why don't I start with those, Amy? I have to confess, I'm a lunch hour. So my first, I thought you did a good job, Suzanne. And my comments are really pretty minor. But my first comment is on what is now, well, it's footnote 2 on what is page 2 in the markup version. And so this language says, for purposes of this opinion, the committee assumes the attorney has correctly concluded that he or she is in such a mandatory withdrawal situation, comma, and does not address the merits of the decision that the case lacks merit, or all the ways that a mandatory withdrawal situation may arise. I just thought that the merits of the decision that the case lacks merit, this just seems kind of awkward. I wondered if we need it. I mean, we're saying, but the point is, we're assuming that he's correctly concluded that it's mandatory withdrawal, right?
Yes.
And we don't, and we're not addressing all the ways that a mandatory withdrawal situation may arise. I think that makes the point. I just thought the extra language does not address the merits of the decision that the case lacks merit. I mean, we're already saying, we're assuming that he's made a correct decision that this is mandatory withdrawal, and we're not purporting to address every scenario that might require mandatory withdrawal. But I mean, this was the point about, people arguing about whether you should second guess your client. And the whole point we made before is we're starting with the starting point is we're assuming that a correct determination's been made. It's just that I just think that you don't need that.
I think I know I agree.
It's kind of awkward.
Yeah. No, it is awkward to use merit within 3 words of each other. But also, I mean, conceptually, I think what I was debating, I'm still not sure about, was, so many of the public comments on this were, you can never be in a situation where your case would lack merit and you would have to withdraw because, evidence is an illusory concept, all of this. And then the other side was, there's no way that you can go forward if you think that your case lacks merit. So it was more about, we're not attacking, I wasn't sure if we should be explicit, we're not attacking whether or not this person is correct in deciding the case lacks merit. And so I couldn't decide, so I ended up putting both in. But I wonder if we need to be that specific, or if it's okay to just say that the attorney has correctly determined he's in a mandatory withdrawal situation, or should we say that the attorney has correctly determined that the case lacks merit? But that to me, how is that correct? So maybe you're right, we should just take out the.
Yeah, I mean, because, I don't know, that kind of suggests that's part of the analysis. I mean, it seems to me that the whole point was we wanted to say to people, the starting point is already built into this is a starting point where there's already been a correct determination.
Right.
The opinion isn't about how they got to that determination. So I think it probably is less confusing to just say, you know, we assume that, you know, we're assuming that he made a correct decision, that there was a mandatory withdrawal scenario. We're not purporting to address all those types of scenarios that could be mandatory withdrawal and move on here. I mean, this is right at the beginning too. So.
Right, yeah, that's fine.
So we want
So
to,
take out the new language there, huh?
And then would it go back to that?
Comma, well, I think it's and.
Yeah, okay, it does not address all.
And does not address all of the ways mandatory withdrawal situations. So that was one. What else? Okay. Over on page 5 of the markup, the last full paragraph there before footnote 9. I think I raised this issue before, and maybe it's just me, but I noticed that we had such an attempt. Well, I should give you some context. So it says. We're talking about Kirsch and Matter of Hickey, which makes it clear the attorney who concludes a client's case lacks money may not simply abandon the client's cause without taking steps to protect the client. We found no authority that would prohibit an attorney under the circumstances present here from attempting to negotiate a settlement of client's claims, and indeed, such attempt may be, and we've changed appropriate to necessary, to avoid reasonably foreseeable prejudice from attorney's withdrawal. And I don't want to rehash old ground, but I think we had a prior discussion about some sensitivity to whether we want to suggest to lawyers, you know, you would absolutely have to try. I mean, some lawyers might say, I need to get out of this, and I think what I should be doing is seeking to withdraw. And to be so affirmative as to say, preventing reasonable foreseeable prejudice, not just a question of could you try to settle the case, but you may need to as part of your obligation on withdrawing. To me, it's a little too strong, and I prefer something that's softer, like it may be appropriate. And I thought we had this discussion, and maybe it's just me, but I noticed that got changed.
Two things. Appropriate seemed like the wrong word. Like
Okay.
whatever it is, appropriate just seemed wrong. So that was sort of what I started with. And then this was, I think, a comment that we got from Prec. That said something like, that there are circumstances where, at least in their opinion, it may be necessary. It's not is necessary, but there are circumstances in which it may be necessary, and they kind of wanted that. And I agree with that, but I also don't think it's like pivotal to this opinion. I think there are certain circumstances where it may actually be necessary to do it. And I think saying may be necessary isn't the same as saying is necessary or anything like that. I think it's couched enough. But if we change the word, I'm okay with it, but appropriate just seems wrong.
Okay, well, that's
So,
fair.
yeah.
If, to that comment, if that's what we want to do, then I would say we should make that clear, because what it's saying right now, it's very specific. It's saying prohibit the attorney under the circumstances present here from attempting to negotiate a settlement of client claims, and indeed, such an attempt, which if I'm the reader, I'm going to say meaning here,
Right.
may be necessary. And to me, that just seems confusing, that the reader's saying, well, do I have to do it or not do it? So if the point is, there's no law that suggests that under these circumstances we couldn't do it, and indeed there may be some situations in which it would be necessary, then I think we make that point. But right now, it makes it sound like we're equivocating on, or even suggesting that under these facts, it's necessary.
That's
And
a
I
good
just think
point.
that's debatable.
Yeah, that's a good point. And it also begs the question of whether we just take out the whole clause. But, because, are we getting into that thing where we're talking about what you do when the conflict arises, like in the last opinion? Like,
Well,
are we
yeah.
going further? But
Right, I mean, I
thought it might
thought
be
of that
helpful.
too. We could say present here from attempting to negotiate a settlement of client's claims, period.
Yeah.
And I mean, I would be okay with that too, quite frankly. I think this is, not necessarily disagreeing with it, but it's kind of,
If it's in, it should have that language you just suggested, which is under certain circumstances or something.
but then I was gonna say, why are you talking about something different than what the facts are now? I mean,
I'm fine with
personally,
that.
I'd be fine cutting it off at client's claims, but,
Yeah,
period.
yeah, unless somebody feels.
Anybody have a strong contrary?
Because it does set up a conflict also. These situations, what you've done at the back, by way of suggesting all the pitfalls. I mean, a lawyer could perfectly reasonably, it seems to me, often feel, I'm not going into that minefield. Right? I'm not going into that minefield, and I don't think we want to set it up so that lawyers sort of make that decision, which is a very reasonable one.
Right,
And,
right. Right, that's a good point.
They feel like they're looking.
Okay, so maybe we'll just cut it off at claims?
Yeah, just period and then keep, yeah.
Yeah, no, I think we should keep. Okay, and then jumping over to page 6 of the markup, under heading B, steps attorney may take to avoid prejudice may be tempered because attorney has knowledge the case lacks merit. That first sentence, or excuse me, second, well, it's only one sentence, I guess. Where it says attorney's ability to advocate for such a result may be significantly or even severely limited by his duty of honesty. I mean, I'm just being picky, but that seems a little, why not just say maybe significantly limited? It just seems kind of overkill, is maybe significantly or even severely.
Right.
I mean, they're kind of, if it's significant, it may be significantly limited, but you can have all sorts of degrees of severity, yes.
Yeah,
That's just an editing.
so just take out or even severely.
Just say maybe significantly limited. Yeah, just,
I just want to say that since we've struck the end of A, it's where we say it may be necessary. In the beginning of B now, we're saying it may be necessary, aren't we? Attorney may have an obligation to take reasonable steps, which may include seeking dismissal or settlement. I mean, I guess it's dismissal or settlement. We haven't said that before, right, now,
I
because
mean,
we just struck it.
you could start it saying attorney's ability
Yes.
to advocate for settlement, dismissal or settlement,
No, not dismissal.
or settlement may be significantly limited. Yeah, I think that's good. Okay, so we're under paragraph.
So
or
just
heading
take out
B.
the clause which may include seeking dismissal or settlement. So we just start, although attorney may have an obligation.
No.
No, she's saying that.
Whole thing.
I think the first clause should remain.
It could, but I don't have a problem with it. In fact, I mean, I think the attorney does have an obligation under,
So then isn't the point of the first clause then really is to say, although the attorney may seek to settle the case.
Right, there you go.
Yeah,
Yes.
right, right,
That-
okay.
yes.
So although
Yes.
attorney may just seek settlement of the case,
To settle.
yes, to settle,
To settle.
the attorney may.
The case, and then it picks up, delete everything. Attorney's ability to advocate for settlement may be significantly limited.
Have we gendered this attorney?
I feel like it's a he.
I just feel I'd rather not use attorney twice, so I'd love to use he or she.
His,
Okay,
yeah. So you want to change to his.
okay, second one.
His ability.
Yeah.
All right, then on page 7, the first top paragraph there, the last portion that has the sentence that says, similarly, it is unethical for an attorney in settlement negotiations to make not only false statements of material fact, but also implicit misrepresentation. Which is a friendly edit suggestion, just to say in settlement negotiations, to make implicit, I would strike not only false statements of material fact, we just said that. We said you can't do that, that's the first thing. So I think you could just say similarly, it is unethical for an attorney in settlement negotiations to make implicit misrepresentations of material fact. That's the point you're making, right? That's the second one.
Yeah.
And this is super picky, but a couple lines down there, third line down in the next paragraph. I think it's if the concealed information is required to be disclosed. Right?
Yeah.
May not knowingly assist. I just think I have one other comment that down in footnote 10. So that footnote is off of the very first sentence of this page 7. And that sentence, this is the second point you're making. It says, second, in negotiating any settlement, an attorney may not wrongfully conceal information material to the negotiations, and then you drop the footnote. And you say, this is but one example of a circumstance in which information could be wrongfully withheld from the other side in settlement negotiations, thereby falling within the prohibition of fraudulent concealment.
Yeah, this is a,
I was
this
kind of thinking,
footnote
like,
was on
what
a
is-
different sentence.
What is this? I was having
Yeah.
trouble matching it up.
This sentence, I was sort of taking suggestions from Steve, which were really good, and I think I debated whether or not to give an example. That sentence originally had an example in it,
Oh, okay.
and then I took the example out. And I don't remember now what the example was, but it was, you know, it would come out if we don't put a specific.
So 10 will come, yeah,
Yeah.
okay. Yeah,
Well,
just-
the next sentence talks about 6106, including concealment.
Yeah, but it's saying this is but one example. When you drop it from the second thing, it makes it seem like negotiating a settlement, wrongfully concealing information material to the negotiations is one example of something.
I think we originally had in there, like, for example,
Okay.
if attorney was under, a duty to disclose information, and that was, and then I took it out because I thought we were potentially getting into the weeds with specific examples.
Then I think we should just get rid of the footnote because it doesn't, right? It
Yeah.
doesn't have the example in it. There's one last comment on the very last page, page 8, the first full paragraph there.
Put it in? There?
So the next page. Yeah, so this first sentence, attorney's compliance with these obligations should often, if not always, limit the ability to make a persuasive demand going beyond exchange of releases to accept a prior offer from the defendant that does not reflect an awareness of the evidence refuting liability. So this is what Suzanne was talking about earlier. We say, look, you're going to have a significant limitation, and it may impact what you can, do as a practical matter. But if you can comply with all this stuff, then it doesn't preclude the possibility of some kind of payment. I just wonder if that first sentence is a little too extreme. I mean,
Maybe the-
I think it might. I think you say something like attorney's compliance with these obligations may often limit the ability to make a persuasive demand. But, should often, if not always, just seems kind of like we're saying it's inevitable. I mean, the point here is, if you can do it, and you can comply with these limitations that exist, that we pointed out now at some length in the prior discussion, then that doesn't preclude the possibility of, minor some aggregate default.
So it should be, take out should, right?
Yeah, I would say may often.
Yeah.
Take out should and take out if not That's it. Amy?
Yeah, I feel like I haven't given it the careful read that I should have, but, but I thought Drew's comments were really helpful, and, I think one question I had is staying in section B, where it's going through the things that, sort of limitations that the duty of honesty places on an attorney in the paragraph second. So first is about affirmative material statements, and the second is about concealment. And so, you make the point that you can't conceal information. Although I wonder if it's not, I wonder if the first sentence, the topic sentence of that second, after second needs to be nuanced. Maybe not. I mean, we know, the tricky issue here obviously is you only have to disclose what you're required to disclose or what must be disclosed because of other statements that you made. So that's a pretty broad statement, but I think it's not incorrect. You can't wrongfully, I mean, obviously, wrongfully you can't do it. So that seems okay. And then you say concealment is moral turpitude as well. Then I wasn't sure what the final sentence was adding. I wasn't sure what you were thinking. Similarly, it's unethical for an attorney to make, I think we've adjusted the sentence, but to make false statements and also, and
Make
implied
implicit-
misrepresentations are also
implicit
not okay, right? So you can't conceal and you can't make implied misrepresentations. I mean, I think that seems right, but I couldn't really think of what that even means, and it felt like,
Half-truth,
yeah,
which is the form of concealment.
right, I agree. I guess it's, so then I wondered, when I read that, I thought, okay, well, what is that ethics opinion she cited to say? But I couldn't really understand, because you're suggesting this is something in addition, similarly, so it's similar, but it's not the exact same as what you've already said. You can't make implied statements. And I wasn't sure what that was other than what's already been said, and I wondered about what that citation is to.
So, so the citation is to the settlement negotiation opinion. And I think it's a slightly different concept because the acts of moral turpitude include concealment. And then the next one is really just a thing saying no distinction can be made between concealment, half-truths, and whatever. And then we have this other thing that says, and you can't do half-truths either. So, I mean, it's true, it's like they almost are repeating each other, but the other, matter of Dale are just saying, oh, no distinction can be made. But it's, and then we have this additional authority that also says, oh, and you can't do half-truths in settlement negotiations.
Right. So you can't conceal, and concealing includes half-truths.
I don't know if it does. I don't know if concealment and half-truths are exactly the same. It's that first thing that you said.
They
disclosing some
require-
facts and then those facts become misleading for the absence of the other facts.
Right. I mean, what all of this is sort of working against is this core idea that generally you don't have multiple things to the other bad things like a case to the other side, right? But countervailing that is if they asked you and you lied, you can't do that. And also if for some reason you have it, if you have a duty for some reason to disclose, right? So I guess I'm wondering, and this, we couldn't do this here on the fly with the group, but I wonder if that's the concept that first needs to come out, is that you generally don't have an obligation. I don't know, but so that's not very satisfying. I guess my comment is just that I found that last sentence of that paragraph, that starts second, to be a little vague, and it worried me because I felt like I don't know exactly what an implicit misrepresentation of the material fact is. It feels kind of vague to me, and I don't know what I can and can't say if I'm an attorney in that position.
I had follow-up to that. I like the more inclusive addition to retain that additional language, cautioning against implicit misrepresentations, but as I thought about it, I had questions that arose in my mind about what does or does not fit into that. For example, an attorney seeking to reach a settlement when confronted with this ethical bind, is it permissible to say, we are confident about our success. We are more than willing to take this to trial. We are prepared to allow the court to make the determination. Those appear to be implying more neutral statements such as, we would like to settle the case. Is there something you could propose that perhaps help us settle the case? There's probably a gradation of statements that contain within each of the statements differing degrees of implied, not just opinion, but implied information, indirectly reflecting that. I think you understand what I'm asking. I don't have an answer to that, but again, I'll say I like the idea of a more inclusive caution. I think that's helpful, but that was my question.
I mean, you raise an interesting issue because it's the very paragraph where we had an example in there. So it's like I was toying between, should we put an example in there or shouldn't we, or shouldn't we, or shouldn't we? And so, now I'm, thinking maybe we should because of your comment, and it's a good one. I mean, what is an example of this? And I'll I'll look up what example it was that we had in there before, but it does go to that, can you say that you have an eyewitness, when you don't? That's an obvious lie, but can you say, the evidence is going to corroborate my client's story when you know that it won't? I mean, I would say you probably can't say that, but I also know that we don't necessarily want to get into the, specifics of that. I'm taking this case to trial when you're about to withdraw. Yeah, I think those are all really interesting issues, and so maybe we would benefit from putting in some kind of an example, because I remember that was one of Steve's, some of his feedback as well. Like, this whole concealment thing is like a whole body of law in and of itself, and so that was the original point of that footnote that says, look, we're not getting into every possible variation, but here's one example. So maybe it would be beneficial to try to come up with an example, that we like, and then keep that footnote that says we're not talking about all of the possibilities. And then to address Amy's, and the comment that implicit misrepresentation seems kind of, not clear. I mean, that Puffrey opinion is pretty clear about what is and isn't. So maybe we put a parenthetical, like discussing multiple scenarios in which, negotiation, what can be said in negotiation or something like that, because that opinion does go through a whole bunch of stuff.
Does that opinion talk about the concept of implicit?
Yes.
I mean, you use that term, implicit misrepresentation.
I would double check it,
Yeah,
but I'm
you
pretty
refer
sure I
to
would pick that up.
an ABA opinion that gives the example of somebody filing a personal injury lawsuit and not disclosing that the plaintiff is dead.
Okay.
So
Hersey versus Branch.
Well, would it, not that we couldn't put in an example, but if we clarified through, I mean, I agree that it's not going to be intuitive necessarily to everyone what an implicit misrepresentation means when they read that sentence. But if we have that sentence and we're citing an opinion that uses that terminology, we have a parenthetical that explains, it's sort of saying this concept is discussed by this opinion. So even if it's not, on its face, apparent to you exactly what constitutes that, go look at this, opinion.
I wonder if you could soften, there are two thoughts along those lines. One is that the opinion, as I'm looking at it, says implicit misrepresentations created by a lawyer's failure to make truthful statements. So it's the implicit misrepresentation in 2015. 194 is actually, it's an implicit misrepresentation created by the failure to say something truthful.
So I think what it is, what that's intended to mean is that if you're negotiating, say, a settlement, there's an implied representation that you have a client, right? So that's what that is, like, that you have a client that's alive, that you are acting on behalf of a client. So it is, so now this is really, explaining why we probably do need to be more specific, because it's not exactly clear. But it's supposed to be by what you're doing or saying, what are you implying by what you're doing, not just by failing to disclose. I understand it's a very subtle difference, but the idea is that certain things that you say or do are implying the existence of some other thing.
Right. So it's a sophisticated version of half-truth. It's
Right.
an because the truth is only implied.
Right.
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 Or
So it's a
something like
little
that.
different than an half-truth.
Yeah, no, with you. I'm just wondering if we want to,
Maybe we pull the code or something.
or.
I mean, the quote could be one way. Again, I mean, I think if we have the terminology correct, not to be lazy, but because what we're doing here is we're saying there are these other principles that exist, but we're not redoing the Puffery argument. We're not doing a whole opinion on what each one of these first, second, third things would be in different factual scenarios. If we have the language right and we cite to that opinion and have a parenthetical that, this opinion discusses these certain types of issues, is that sufficient? Do we really have to get into it? We would have an example for number one, and then an example for wrongful concealment.
It's true.
I mean, I just wonder if we're getting to it. I agree, and Steve's point's a good one, and to Amy's point, I mean, when I read this, that kind of stuck with me too. It caused me to say, well, wait a minute, what are implicit misrepresentations again?
Right.
I gotta,
I feel like I couldn't open my mouth in negotiations.
So like the example from that opinion is that if during negotiations you include a list of the plaintiff's damages and it includes a separate component for lost future earnings, that's an implicit misrepresentation that the plaintiff has not yet found a job. And in this case, they have.
Right.
So it's what's implied in what you're saying. And you're right, that APA opinion does say it's implied from what you don't, truthfully disclose, but that's what they're talking about. So
Right.
we can either do a parenthetical.
Yeah, I feel like Drew's suggestion that we cut it back, and so we don't just suggest that you might want to look at this
Yeah, that's fine.
without putting it out there, because I think Stephen's list of alternative ways of framing it. I mean, are you implicitly representing that you have a meritorious claim by trying to sell it? I get anxious about implying that without a lot of thinking. More thinking than we can do.
You could say similarly, it's unethical for an attorney in settlement discussions to make implicit misrepresentations, if that's the right language. C, Cal State Bar, such and such, paren, discussing, situations that involve implicit or may involve, whatever the language, but
I wonder if we should also cite the ABA opinion. I mean, normally we weren't citing ABA opinions because we didn't have the model rules. But that ABA opinion is under 4.1.
and 2015's citing, right?
Right.
So I don't see, to me, I don't have a problem citing an ABA opinion. just say implicit misrepresentations. See Cal State Bar Formal Opinion number 2015-194, discussing examples
Yeah.
of implicit misrepresentations or something like that. And then you're saying, look, if you don't understand what this means, which probably most of us don't off the top of our heads, go look at this opinion and it gives you examples of what would be an implicit misrepresentation.
Well, I think if you ended the sentence with, but also implicit misrepresentations, period, without limiting implicit misrepresentations to only facts, then you broaden the statement. Then whether you do or don't include specific examples, you have now communicated that the caution against implicit misrepresentations is not limited to just implicit misrepresentations of fact. There can be various
Yeah, well, and that's consistent, I think, with what Suzanne is saying. The actual language doesn't say of facts, it says implicit
Right.
misrepresentation. So if we strike of material facts, so now it just says implicit misrepresentation, see this opinion, for example, discussing examples of implicit misrepresentations, and see the ABA opinion, which is actually cited in the California.
Yeah, it's 06-14.
06-439.
Yes.
Does that, you think?
Well, first of all, I just, just for reading purposes, if we could move in settlement negotiations to the end of the sentence. Just because I find it hard to read that way. It is unethical for an attorney to
Yeah, let me just
lie misrepresentations. Make implicit misrepresentations. Yeah. That seems okay. Okay, so yeah, I don't have anything else. I think it's really, you did a great job candidating the new rules.
All right, so I guess I'll open it up to the rest of the committee.
Can I see the issue on the clean copy? Yeah, we gotta change that rule. That's the old one.
Good catch.
Old issue.
Yeah, well, just change it from 3.7
Yeah,
to
1.16.
And then I just have a stylistic thing for, looking at the clean copy under room numeral number 2. Second paragraph that starts with even.
It starts with what?
Even.
Even.
Oh, right.
The very last sentence there, instead of starting with if neither, can we start with the attorney must continue to represent the client and continue to satisfy all ethical and other duties to the client until either substitution? Like just put the first part of the sentence at the end. Or permission to withdraw is granted, yeah.
So the attorney must continue to represent the client and continue to satisfy all ethical and other duties to the client if neither substitution nor permission to withdraw is granted.
Well, they have to, in order to get out of the case, they have to get substitution or permission to withdraw, right? But until
Right, but
that
then
happens.
what happens if they can't get out?
Oh, well,
I think that's what that sentence was about.
okay.
Go back.
I thought the point was that while they're waiting for that, or until that happens, they have to continue. They can't just stop because you're reciting above what happens in these other cases.
Right, so I think that change was something that, based on a comment that we got back, that we didn't take into account, in our opinion, the situation where you might not be able to get out.
Gotcha.
So maybe we need to say what you said and then also say, oh, and if you can't get out. But you're right, you have to keep doing it until you get out. Okay, so the one here, until the attorney is either formally substituted out of the case or has been relieved. So I think we said it there, and then the point of asking is to say, oh, and if you can't get out, basically you're stuck. But that you still have to fulfill your duties.
So, yeah.
But I'm fine with moving that clause to the end of the sentence if you get read that way.
Well, I think actually now if you focus on what you just highlighted, that you made that statement, then it does, you really are saying then, and if that doesn't happen, you gotta keep going, in which case I think the way you had it arguably
Yeah.
reads better.
I'm fine with it.
Yeah, that's fine.
Anybody else?
I have just a question, which is at page 7 of the, in the section on prior material misrepresentation or wrongful concealment of material facts concerning the merits of the claim. But then it goes on and says, if the concealed information was required to be disclosed, right? Isn't if the concealed information was required to be disclosed implicit in the idea of wrongful concealment? At least that was one question I had. The second is down toward the bottom. It says the attorney corrects the misapprehension, and I'm okay with that, but I wonder if that's what we're saying or whether it has to be a misapprehension resulting from the non-disclosure, or maybe that's slicing the salami too fine, I don't know. But those are just two questions, Suzanne.
Yeah, so the first one, let's talk about the first one first, because I see.
Page?
So it's at the top of the first part, third, lawyers may not knowingly assist the client, and then it goes on, based upon prior material misrepresentations or wrongful concealment of material facts concerning the merits of the claim, if the concealed information was required to be disclosed. And Steve's question was, we need that last clause, because if the concealed information was not required to be disclosed, it's not wrongful concealment. So that it's like it's making it sound like you could have wrongful concealment where there's
not
no
required.
obligation to disclose. And I can't really think of a situation where you would have an obligation to disclose. Like where you could have wrongful concealment outside of that situation. So it might just make sense to take that if clause out.
That's all.
I think I'm talking about the same thing, right? Which is, so I looked at the digest, the last sentence of the digest, nor may the attorney settle. And it's just the sentence construct, it's a very awkward sentence, by the way. It has a lot of clauses and sort of lacks flow in my opinion. In the study to figure out exactly what it means, but I thought, there's a lot of stuff, cases settle all the time. And stuff hasn't been disclosed yet because people serve discovery and you objected and you know they're entitled to it, but you objected and they didn't make a motion, or you just reached resolution of it without people. They just decided they didn't want to fight about it. That's not wrongful concealment. And so I was more, and then I went looking for where this was in the opinion. says, and you did, I was more comfortable saying something was wrongfully concealed, because that to me suggested there was more than sort of the normal process of fighting about discovery, where you know you're gonna give things up, and to some extent, you're gonna make the other side earn it first. There's nothing unethical about that. That's not a wrongful concealment. But if you settle before they take full discovery, even though you've objected for various reasons, even though these objections that you anticipate conceding, I wouldn't feel any obligation to hurry, well, you better finish that deposition, or we better resolve these privileged objections I've made, hint, before you settle this case. I don't think that's necessary. That's not wrongful. I think wrongful to me implied that you said something did not exist, and yet you knew it existed.
Right, I think that's what this opinion is talking about, wrongful concealment.
Right.
Which certainly can happen when you have the obligation under the existing discovery statutes to produce something and you don't. But it's not to say that every time you have a discovery dispute, you're wrongful.
Right, yeah, that sentence in the digest wasn't dialed in as precisely as, I thought it was not a correct statement. Just because it's required to be disclosed by discovery doesn't mean that you have to wait for it to be disclosed before you can sell. Why wasn't it disclosed? And then you correctly discussed that it's wrongfully concealed.
Well, what's that?
What if you took out just the applicable discovery rules? So, I agree with you, Matt, that it's only wrongful if they've specifically asked, you said you would produce it, and you didn't produce it, right?
Or you said it didn't exist, and you
Well, that's wrongful, no question.
believed it existed.
Right, but it is complicated, because
Right.
there are lots of times when you object, and like you said, maybe you make specious objections, but they don't follow up. That would be wrongful, but
A losing objection.
What's that?
I think it's losing. I mean, you're making a frivolous objection, right? That's why I think you want to.
Oh, fair enough.
Yeah.
But no, I think people don't disagree with what Mac's saying. I don't think that's what the sentence wasn't trying to say. If the case were to go along and someone asked for such and such, you would be obligated to produce it. Therefore, settling before that request comes in is somehow wrong. I think that the discussion of this is on page 7. And it's the example at the end of that paragraph where it says, thus here, for example, if attorney's conclusion that the case lacks merit was based on information wrongly concealed from the opposing side during discovery. I mean, I think what we're trying to say, if you were asked for it and it was concealed, you can't, that would be different. Right. But the fact they haven't asked for it yet, and could theoretically, if the case went on, I don't think.
Yeah, I'm okay with at 7. I think that's fine. I just thought that the digest, that sentence could be cleaned up.
Well, to Amy's point, I mean, what if we took out the discovery reference and just said, nor may the attorney settle if the attorney knows that information bearing on the merits that was required by law to be disclosed to the opposing party was not disclosed. I mean, that's the path. I mean, if there was information that was required to be disclosed and wasn't disclosed, and now you're deciding, can I settle this case? I mean, doesn't that, I think that takes away your suggestion that someone could read this, I mean.
Why not wrongfully concealed?
Yeah,
okay. Put the wrongful concealment language in again at this point.
Which was wrongfully concealed.
That material information bearing on the merits was wrongfully concealed.
Well, okay, although then aren't we focusing on one of a handful of things we've articulated? I mean, required by law seems broader. If we say wrongly concealed, we're focusing on the second out of our 3 examples that are back into the opinion.
Or you can make, I think wrongfully concealed could work there. Because isn't that, and, you know, the other examples are affirmative misrepresentations and things like
The
that.
system has detected that a minimum number of lines are connected to this conference.
No way.
Do you want to continue your meeting? Press
Okay,
1
so
to
we-
confirm. If there is no
Because when it
So,
comes.
so maybe you're right, Steve, because we've already covered the first, which is an affirmative, and we said that in the sentence before, right?
Right.
So we have covered that. So when you get to 2, we're talking about concealment. 3, we're talking about,
Aiding and abetting.
This doesn't say anything about half-truth. Never mentioned it. Because if it's tracking the discussion, right, we talk about affirmative misrepresentations. But we don't talk about,
I mean, you could say, I don't recommend this, but you could say, call it, you can't make express or imply false statements of material fact, but I just think that.
wrong, let's just stick with wrongfully concealed.
Yeah, I like that.
And then, but then we don't approach, you know, you can't assist your client too, but I don't know that we need to say that.
I don't think so. That just doesn't need to be a complete.
so Matt, is that?
Yeah.
Seems like that.
That would just be wrongfully concealed, period.
Yeah.
Period? Right, and attorney and the client does not consent, it's just. Because we're not saying, look, if it was wrongfully concealed, but then you get the client to agree that you can.
Well, you can't sell without disclosing information that the attorney knows that is wrongfully concealed.
Remedial measures, don't we have remedial measures?
That's Matt's,
Yeah, he loves that.
that's demonstration opinion.
Remonstration.
Okay, because I like that. I thought there were like corrective, I thought we said something about attorney would have to correct the misapprehension. Unless attorney corrects the misapprehension of facts. So we could just say, unless attorney takes corrective action. I just don't want it to suggest that if information was wrongfully concealed at any point during litigation, you just can't settle it. So, you know,
Yeah.
unless sufficient.
It really has to be wrongfully, the illness to be wrongfully concealed, that you or your client are somehow responsible for the wrongful concealment, and you believe that wrongful concealment is going to impact the settlement.
But that last one is packed into material, I think.
Right, I mean, is that happened, and then you can't get the client to allow you to now disclose it? Like, the client's not letting you take corrective measures.
Yeah.
So was wrongfully concealed or the client not agree to corrective measures?
Will not consent to. And client will not consent to. I don't like, okay, sorry to like, because it's so hard when you like pull something out, but I remember another aspect of when the attorney might not be able to do it, wasn't just, wrongful concealment. We talked about, you know, when perjured testimony is in the mix, but you didn't know it at the time, and you now know that, you know, your client doctored a document. And the doctored document is produced, and you now know from the client that they doctored it, and it's out there. So it's not just concealment, it can be, there's false information out there. And that was something that was in here in the discussion. So it might just be,
I'm having a heretical thought. Why don't we just say that, however, in all cases, the attorney must comply with her duty of honesty in settling the claim, in attempting to settle the claim, period, full stop.
right, and then we talk about
And
it
then we-
more
and-
fully.
That's a good idea.
That's too easy.
Let's see, where do you stop? Let's see.
It's hard to
Okay.
get around that.
As in all cases, the attorney must comply with, do we have a gender for this attorney?
That was
Boy.
Well, no, this is, the he is in the hypo, but now we're in the digest with just.
Oh, that's true. Yeah, however, as in all cases, attorneys may not.
Must comply
No, we
with
started
their.
with
Or
that attorney.
it may include settling the claim if the attorney can do so consistent with his duty of honesty.
Yeah.
Yeah, so, right, and just put as in all cases, because that was, some people expressed they were confused, like, are we saying that only lawyers in this situation have a
Right.
duty of honesty? Which of course not.
That is, we don't have to pander to that.
I know, but I mean, I sometimes, I get concerned if it causes confusion for one person who took the time to write, you know,
That's
a
very,
public comment.
that's very generous.
Yeah,
I
that
think
it might be
take the time to
confusing
write.
other,
So, such reasonable steps may include settlement if, as in all cases,
Oh,
Or
comma,
just say if
comma,
the attorney can do so.
right, if the attorney can do so, consistent with his. The duty of honesty.
their duty of honesty.
The attorneys. If the attorney can do so consistent with the duty of honesty.
I guess
I do
people would
think it
read
should
it.
say the attorney's duty of honesty. The attorney's duty of honesty.
And then the rest of that just.
And then,
All that comes out.
oh, and then Steve, you had another.
Just what, the question was whether in the line immediately above, at footnote 12 on page 7, where it says the misapprehension, was it any, I wondered if it was any resulting misapprehension. Was it- Maybe I could say, correct the misapprehension, just say any resulting misapprehension. That's it, that's all I got.
Anybody else? Any other comments?
Scroll up for a second, I just want to make sure that other changes. Okay.
All right. Is there a motion to this?
What do you suggest the motion to do? Just to,
Is there a motion to approve this to be sent out for public comment?
Because it has to go out, right?
Yeah.
I so move.
Guys,
60 days.
Okay, ready? Andrew Dillon.
Yes.
Amy Bumsey.
Yes.
Andrew Hudson.
Yes.
Amy Bundy.
Yes.
Eric Dykes. Justin Fields. Matthew Hodout.
Yes.
Joel Osment. Marla Richardson. Dina Roach.
Yes.
Teresa Schmidt.
Yes.
Lucia Alessing. Richard Solomon. Steven Sparta.
Yes.
Marcia. Thank you.
That's who it is, like, goes out and comes back really quick and no one will say anything.
This will be the
Yeah. Who gets to handle the public comment?
We expect to get a strong letter of support from you here.
As
fast as a private citizen.
So it's enthusiasm, right, Matt?
Spencer, she is.
This is probably the best ethics committee that has ever come from us.
All right. Okay, so,
Someone wants to go back.
2:30, yeah, let's,
Oh, too good, Kathy.
you got that, yeah, okay. Let's do,
Perjury.
Perjury.
It's that time of day.
14:04.
It's that time of day.
Yes, we're going out of order, mix things up.
Why are we going out of order?
Because he has to leave.
Yes, he has to leave, so. All right, so 97 to 115,
Yeah, look at the red line at page
the
106.
red line starts at 106,
Right,
right?
and I remind you all that every time we do this, you tell me it's ready to go. And couldn't imagine there being any further comments. It's like, it's be like trying to correct Serena's serve or something like that at this point,
Are you
okay?
comparing your writing to Serena's serve?
This is a work of the committee. So, what did I do here? I wanted to make it even more clear that the testimony was crucial to the outcome, and that if the attorney didn't do something, it'd be equally clear that the attorney was sort of endorsing the person. So I added some adjectives, and you'll see. For example, at page 107, lines 53 to 54, added that it was crucial and the plaintiff may well lose, the client may well lose the case. I also, similarly, to beef up the hypothetical, to make it clear that the attorney really does have a quandary, is that it's not just that it's there in the case, it's clear to the attorney that the attorney's has, in fact, said, been endorsing the testimony, lines 73 through 77, used it in an opening statement. The witness testified, of course, there's some perjures in the case, cross-examined somewhat about it. Just as that. I also added some things. I thought it was important in just not to just flat out say to people, this is on page 3, lines 94 through 104. It's not easy to, there are two thoughts that I thought would be helpful in educating people. One is, it's not just, gee, if you don't know it's perjurious, then you can go run with it, because that's cool, but it's you have this important duty to be a zealous advocate within the bounds of law. In fact, there's pretty good law that says you're entitled to and should draw presumptions of credibility in your client's favor. I think this makes it easier for lawyers to come to grips with that. Also, in this state bar opinion was done in 1983. That's at line 104, which I think is in some ways it's a flawed opinion, but it was useful in others. It actually talks about how it's very difficult to know when something really is perjury. So that's the purpose of those changes. I did, we did more research on what materiality means, and we think we found the best case, which is People versus Rubio. it's apropos to what Steve brought up. There was some. The Supreme Court has used different words, but this People versus Rubio case and the research that someone did, and I went and verified it myself, that was the correct statement of the law. Could probably influence the outcome of the proceeding. That's page 6. Added reference to BPC 6128, that's line 140. That was pretty good. Spent more time trying to understand what it meant to be the captain of the ship. Because it's a weird metaphor. And it's just a quaint metaphor, let's call it that. But it really is out there in civil cases. It doesn't quite mean, but it's nuanced, and that discussed that in footnote 9. And it really came to scenario 3, which is the most difficult one, where, if you recall, there were some flaws in 1983-74. That's the flaw that's the prior opinion that didn't really have the benefit of the considerable expansion of what it means to have a client confidence and client secret. We've seen a lot of it, and this committee has written a lot about. So that opinion seemed to be suggesting that my view of it was, when you think that you may have a duty to let the court know they should be pointing the court in a particular direction. That's something I took from that opinion. But the opinion is otherwise. So we agreed that we wouldn't be relying heavily upon it, but there's still reliance. And that's why you see a lot of the redlining, for example, at pages 6 and 7. And also, in looking more closely at the new rules, I was delighted to see, upon finally studying them as closely as I should, that this doctrine of remonstration is now really in the middle of those rules, and it's a good policy. So, where do I get to that? Page 8 is where we talk more about remonstration, but what I really want to call your attention to is something that I struggled with. I think Teresa brought it up, which is if you're the captain of the ship in scenario 3, and the perjury is already out and loose and running around the courtroom, it's a completed act, and your client says, no, you are not going to, we're going to go forward with this. We're going to go all the way through. We aren't going to correct it. You aren't going to disclose. Well, if you're the captain of the ship, why can't you say, well, I'm just going to strike it? So, did a fair amount of research, couldn't find a spotted calf case, but decided to take a leap. Interested to see what you have to say. At line 263, discussed, can you strike the testimony over your client's objection on the theory that as the captain of the ship, you have ultimate control over evidentiary decisions in civil cases? I don't know the answer to that. I really don't. Couldn't find anything on point. And you'll see that I said, this course may be perilous. And I said, it's questionable. That's line 263. And I don't quite say that you can't do it, but I said, what I'm trying to say, you should be very careful if you decide to strike testimony that will sink your client's case over your client's objection. I think that pretty much. And then 292, talk about something I spent a lot of time thinking about is if the perjury's already occurred and your client won't remonstrate properly, and you have to withdraw, And what if you just decide not to say anything again ever about the perjury? You never refer to the testimony, and you don't mention it in closing argument. Can you get away with that? And I thought, not the way I'm going to draft this hypothetical, which was to say you've already argued for it in opening statement. You already put the testimony on, you cross-examined the supervisor on it, and you made it clear that your case, that's an important element of your case. The other lawyer, presumably in closing, is going to get up and argue against it. And you've just chosen not to mention it again. I think that you are running the risk that you'll violate the rules if you continue to represent the client, and you should probably seek to withdraw. That's why I improved the hypothetical to make it clear that the testimony is absolutely crucial to the outcome of the case, and that you have, and that you've been advocating based on that crucial testimony. I don't think you can just turn your back on it and hope that people will forget about it. That seemed irresponsible to me. So that's why I, along with the way of saying, that's why I increased the amplitude, if you will, of the extent to which you've been using the perjurious testimony before you knew it, to try to make it clear that you don't want to be in a position where you're continuing to implicitly endorse it by reason of your silence. You would have to seek to withdraw. Can I say one other thing that I think is important? Is if you look at footnote, the reason why I think remonstration is so important is at footnote 18. It also gets back to Suzanne's opinion about settlement. I mean, just bolting out of these cases and not remonstrating with the client, trying to cure or remedy the perjury, doesn't help the system very much, because the client may continue to perjure themselves with a new lawyer. Likewise, in your case, if you don't settle, the client will find a new lawyer, and the client won't tell the lawyer about those bad facts.
Well, I think what you said earlier about remonstration being front and center in the new rules is true.
Yeah.
Actually, I think there was a lot of discussion about that with the division commission. So
yeah,
to me, it makes perfect sense to be emphasizing that concept. Okay, so the subcommittee on this obviously matters. So the lead drafter is Steve, Ujvala, and Suzanne. I guess we'll open it up to the rest of the group generally.
Yeah, I did have some comments, but I really like this, Matt, and I think you've done a really good job putting together a lot of comments and a lot of good feedback, and this is a hard area. I was a little on the fence for a little while on this because there is no materiality requirement in the ethical rules. So your duty of candor isn't limited by just materiality of facts. And our opinion is really based on whether this is material, because we're focusing on perjury. And in the end, I thought that was the safest way to go, because then we don't have to deal with what if it's not a material fact, because the ethical rules don't include a materiality limitation. And I don't think there's anything inconsistent with us doing it in this way. We're just taking the more extreme example, and it's probably the safer one. But I did consider that, and so if people come back with public comments on that, I'm saying in advance that I think it's a good idea to focus on the perjury, even though there's not a materiality limitation in the rules.
Just to that comment, I'll say one thing quickly, which is that I actually think it's okay to focus on the perjury, and I like the tweaks that you made, Matt, to address some of these nuanced issues. But just as an aside, I mean, I heard in the last week, in connection with a group of lawyers that were at a presentation where 3.3 was being discussed, and they were very interested in understanding how it worked, and specifically in the context of perjured testimony. I mean, it was just interesting to me. I mean, I think this opinion is going to be really helpful, and there's a lot of people out there that even with the narrower context of perjury are out there looking to understand this especially under the new rule, what's the analysis, what's the process for working through that issue, so, and for what it's
Yeah.
worth.
I agree, I think it's gonna be very good. So on line 52, you have some new language here that says, because the other evidence is highly problematic for client, and then you go on, and I wasn't sure what other evidence, unless you're trying to just say, because other evidence is not good for them, or it
Right.
just looked like you were, maybe you just take out the word the.
Yeah, I'll delete that.
Yeah,
So I highlighted the same thing. I don't know if this is what you're suggesting, but I would just start the sentence with the eyewitness testimony is critical. We never talk about other evidence at all, let alone other evidence that's highly problematic. It's almost a distraction. I saw the same thing. I don't think this is exactly what Suzanne's commenting, but I'm chiming in because my suggestion, I would just start the sentence, the eyewitness testimony is crucial. Without it, the client may well lose the case.
Okay.
If you rely on that later, the other part.
Yep.
yeah, that's good, because then there's a lot of reasons why it would be crucial.
Exactly.
On footnote 4, you're citing a case about client perjury, and I thought you should cite here the OCBA opinion 2003-01, which is also on client perjury and comes to the same conclusion. So I thought it might be good in that footnote, because you're talking about client perjury in that footnote, either C also or whatever you think.
2003-01.
-01, it's on client perjury.
And it should be.
And it does conclude that unless you know for certain. Then at footnote 6, there was a repeated on a, it says on a material matters. Footnote 6. And then where you do have, I thought what you did with the captain of the ship was very clever. Crashing it, what was it, sinking it? I thought it was very clever, I liked it.
Stranding it on the reef.
No, it's perfect where it is. Can you sink the ship? Really good. I thought you might want to cite, because that Blanton v. Woman Care is also cited in the comment to Rule 1.2.
Hold on, show me what.
So you're on, where you're citing
On
Blanton.
the red line.
Yeah, so that's like 263 to 266 area. And then you cite, at 266, you cite Blanton.
Yeah.
Blanton is also cited for the same proposition in the comment 1 to Rule 1.2, which talks about allocation of responsibilities between lawyer and client. So it seemed like a good spot to drop in a cite.
Comment 1 to Rule 1.2?
Yeah, comment 1 to Rule 1.2. Then on line 241, I think you're missing
I'm just going to delete consent, because it already says above, client's instructed attorney not to reveal the perjury. So you don't have client consent.
Well, I was gonna suggest you put in without client
Okay.
consent. Because, just because they instruct you doesn't mean they can't change it.
Right.
And actually, on that point, and this is my last one, is on this very issue. And it's again, when we're in scenario 2, and we're at, 172 to then 173, the next page, we're talking about what the attorney's options are when the client is telling him, I don't want you to, I want you to use this witness. And you say, first, because the attorney can decide which witnesses attorney must proceed without offering the false testimony. And then it says, second, rather than continuing, attorney may request that they withdraw, that the attorney can withdraw. And I thought, well, if we're making the point that attorney is in control, attorney can't put the witness on, attorney is therefore not going to put the witness on,
Are we really telling lawyers that they could still withdraw and leave the client in the middle of a trial without an attorney? Because they want you to do something that you're not going to do. You're just not going to do it.
We'll just insert and say, see your opinion about settling the case from the last. References
See,
other
getting
opinion,
out,
maybe you
yeah.
should try this approach
Right,
before you
like,
withdraw.
do something else. But I mean, it just seemed to me that we were going so quickly to this idea that the attorney could withdraw because their client is telling them to do something that the attorney's just not going to do. And then I think what you're getting at is, does this mean that the relationship is breaking down, right? And I get that, but I don't know. I get very nervous about suggesting that an attorney could withdraw in the middle of a trial.
Well, they can seek to withdraw. I mean, the judge is going to evaluate prejudice.
You know, no, the judge, well, first of all, the judge is never allowed. But no, I'm thinking from the client's perspective. You know, the client's there, they paid for whatever they paid for to get to trial. They make one stupid instruction in the middle of trial, which is that they want you to use perjured testimony. And you're like, well, I'm out of here.
Well, I think, yeah, I agree with you, but I think it should be mentioned that there could be circumstances. I mean, look, if your client is saying,
Right.
we're going to go ahead with this, Suzanne, I know it's perjured, that's okay with me. You may say, I want nothing to do with it. I mean, this client won't, I mean, you may decide, I'm out of here. I can't, nothing's going to fix this. It could be just the final straw. So I could add a discussion that says you may refer to the possibility of other facts that would make you want to get out at that point. But I do think it's appropriate when the client is suggesting the case can go forward based on perjurious testimony. Yeah.
But you're not gonna do it. And we're saying.
Yeah, you're right. I guess what you're saying,
And
if
the
you
client can't force
can
you.
refuse to put it on, yeah, you're right.
But all this says is that you can request that the client allow you to withdraw. I mean, that's certainly allowed under 160B.
Well, it says second, rather than continuing with the trial, you can ask the client to allow you to withdraw, and if the client refuses, you may move to withdraw.
This is scenario two.
And
Okay, I guess I should
yeah.
have read the rest, okay. Well,
I mean, you're right, you can ask at any time.
And, I mean, the truth is the court's not gonna let you withdraw, and you're not gonna disclose why to the court, right? So
Right.
you're gonna be saying like, I'm bringing this motion,
Wait a
it's
second.
never gonna happen, but at least I don't know, maybe that makes the attorney feel more comfortable in moving forward with representation, because the court has denied that request, and then they obviously are not gonna put the
Wait a
person's
second.
testimony.
Suzanne, under scenario two, the trial hasn't started yet.
That's right.
Well, it says rather than continuing with the trial, so.
Well, that's what I meant.
two trials.
This is before trial. You now have learned that your client is okay with perjured testimony. I would think one of your, I'm not gonna do it, or you may say, that's it, I want nothing to do with this. I'm the money to get a new lawyer for trial. And I'll go get a continuance for it.
Then you say continue with the representation rather than trial, because it does make it sound like. Right. You're in the middle of a trial, you
Yeah.
want to dump it then.
I mean, you're right factually, Matt, it is pretrial, but it does make it,
Right.
it makes it sound like you're,
In the middle of trial.
but focusing on that, I think, I mean, and it also is predicated with the client persists. And at that juncture, pre-trial, I think a lawyer could say, I don't want to represent you moving forward. Am I obligated to go through the whole trial because I know I can, contrary to what you want me to do, you know, act in
Right.
a way that, I don't think you're boxed in like that.
No,
Right.
you aren't.
And as a practical matter, if it's gonna get denied, it's gonna get denied. But I mean, to Amy's point, all it's saying is that you can ask, and then if that's denied, bring a motion. But if it's pre-trial, I mean, I think you're right. I mean, the lawyer would go in and say, you know, I can't do this, I wanna get out. I'm gonna ask for, in conjunction with the motion, if that's what I'm forced to do, I'm gonna ask for continuance, or plus I'm gonna have to justify.
Yeah, I think the client tells you, I'm okay if we use perjury, it's great, done a great job the last year, now we're going to trial, you know each other really well. They say, well, I'd like you to use that perjurious testimony. I'd say, it's only gonna get worse from this point forward.
So I agree. I mean, I was definitely focused on this idea that you're in the middle of trial, and I really questioned whether you could ethically pull the, leave a client in the
You
like that.
You can.
And also on that same sentence, one thing that I thought, and I know it's kind of implied already, but just to make it explicit, that the attorney may request, if the client won't withdraw the instruction, to allow him to withdraw. So to just make clear that you're still trying to get the client to withdraw the instruction. Unless you're suggesting the fact that they instructed you to do it at all might give you grounds, and then I think you're just kidding.
But it's all predicated by if the client persists with the instructions.
Well, that's the beginning of the paragraph. Right.
But the third scenario does say there is a section dealing with withdrawal and saying you must withdraw under certain circumstances. That's sort of what you're talking about, too. I mean, you referenced scenario 2, but are you suggesting that they shouldn't do that in scenario 3?
Well, scenario 3 is a little different.
Because you're stuck. The testimony's been out there and the client won't let you.
But this says that you must, so that's
Right.
why.
Well, that's my own fault. That's my error, because in scenario 2, you haven't gone to trial yet. So it's wrong to say at line 172, attorney must proceed with the rest of the trial. I forgot where I was in my own scenario.
Well, we're gonna change that, right? To
Right.
proceed with the representation.
Yeah, I think that's how I got it. I was thinking of a trial.
Right.
The representation. So continue with the representation. So client refuses, at any point the client can withdraw this instruction. So if the client refuses to allow, if client refuses, I know we say it once, but I always get nervous about people just taking one sentence out and go, well, client refuses, I can go. Whereas the client can, and I've seen fights like this and we all have, between lawyer and client, where lawyer says he wants out, then he changes his mind, and the client says, well, too bad you're out, and, they can go back and say, I withdraw the instruction, please stick with me.
Yeah.
So maybe if client refuses.
Client persists with the instruction.
Right, and then you have, first, you don't have to put on the testimony.
Right, I'll correct that sentence. So that sentence of 171, first, because attorney controls, attorney can go ahead and, some people can go ahead and try the case without offering a false testimony. Second, rather than continuing with the representation, then I have to explain that you could decide that you have grounds to request to be relieved as counsel before trial, seek a continuance. I think that's a viable option when a client has told you that they want you to be part of perjury, to be using a case based on perjury.
It's straight out of 116. It says, number 3, in the permissiveness, the client insists that the lawyer pursue a course of conduct that is fraudulent.
Right, so then so I think it's fine at this juncture. In the middle of trial, I really question it, honestly. But at this juncture, I think we can.
Okay.
Okay, Steve, are we following? Any comments before we open it up for?
Follow, you want to go first?
One substantive comment is, about footnote 18. I'm not sure whether we need to keep this footnote in or not. Because it doesn't really go to the attorney's duty to the client or candor to the tribunal, but more about the effect of having a client who wants to pursue a course that no attorney will support. And so it's a burden on the court in a certain way, because if the client keeps getting new attorneys, the attorneys keep refusing to allow perjured testimony and what have you to go forward, dumps the lawyer, gets continuance, and so on. So it is a problem, but I'm not sure it's one that we address or need to address in this way.
What I was doing was explaining why it seemed to me that you see this emphasis in new rules, that the first thing you should do is to talk the client out of it. And why is that? Well, People versus Johnson is cited frequently about perjury. And in perjury cases, which I've done one extended hearing on it, we talked about why the lawyer did the right thing, because it's good for the system to keep a lawyer in who's responsible versus bringing in a dishonest lawyer or an uninformed lawyer who can be used by the client. The client's figured out now, gee, I'm not going to tell my new lawyer about this witness perjury. So that gives the lawyer, I think it's important for the lawyer to understand what I perceive to be one of the most important policy underpinnings about remonstration is that it making the lawyer try that first rather than going, I'm out of here, you're dishonest, we're not going to talk about it. Thanks for letting me know I have an excuse to dump you as a client. I've never liked you, right?
That makes sense.
That
Sure.
you're serving the system. And that's why I think judges prefer that. They're thanks a lot, counsel. This case is still on my docket, right?
Well, I mean, in that case, and that makes sense. I mean, I didn't see it that way, but that makes sense. And maybe we can just refigure that, the footnote to say the policy underpinnings for remonstration as the first step are.
Right, okay.
And just make it clear so that otherwise you read that and you go, oh, you have my reaction. But,
Okay.
and then the footnote makes sense. And,
All right.
and you can
I'll
just figure
I'll
it out.
have a sentence, a better sentence that accompanies footnote 18.
And just a couple of minor points, and this is, just a grammatical point. On page 5, at line 162, it's must remonstrate with the client, not to.
What?
Remonstrate with the client.
Page, line.
Line 162. Demonstrate with.
Yeah, you know how many times I looked up demonstrate to see what preposition you're supposed to use?
And they're all over the place?
I think you're right. I think it's with. You're
It's
supposed to remonstrate.
Right.
Right?
It's not
active.
Yeah.
It is an active.
That's that.
It's a dance, not an instruction.
It's the woodshed.
Dancing with the devil.
Back to page 8, just a quick little cleaning up of a sentence. The same one with references footnote 18.
Line.
At 243 through 245. On line 244, I would say take out seek so that you say to remonstrate with client first and foremost rather than withdraw. So remove seek, turn remonstration to remonstrate, and with client after that, and take out AL after withdrawal. It's just a
Right.
just a sentence in that. But otherwise, I think it's great. It reads really well, and mixes in, it's covered everything.
No one's gonna tell me that you can't strike the testimony. Or no one's gonna tell me you should strike the testimony.
No, should not strike, yeah.
I don't know.
And that would just change
Honestly, I
our
don't know.
representation. All the ways into this.
Steve, anything, or you want me to open it up to the larger group?
I'll go quickly. Line 35, if you go, I'm afraid I have to follow this discussion quite as closely as I should.
Line 35?
Yeah. Duty, candor to the court.
Right.
That's true. See if I can get to something a little more useful. At line 162. Uh,
62?
Right, okay, we've got to change that with the client. I am. And then my main comments are at page 8, and let me say, in jumping in here, that this is the deepest discussion of this set of issues that's out there, in a lot of ways. We've done a lot of independent thinking, and it's really admirable. My first thought is at 247. I think remonstration is one of the reasonable remedial measures. If you actually read that comment, remonstration is the first reasonable remedial measure. To say that you should remonstrate by employing reasonable remedial measures is maybe not quite right. And I'm not.
Yeah, I know what you're saying. I'll type that up.
That's just, I won't, it's not probably effective to try and redraft in the meeting, and I didn't. But that, and then corrective action, right, is sort of a subhead of what you threaten when you're remonstrating. Right? You say, because you can't take the corrective action without, or at least you can't, in this framing, what you're saying is, there are some corrective actions I can take if you give me permission. So it's part of the remonstration process. That's all I'm saying.
I want to make sure I capture that. What, the last thing you just said, what was?
No, I actually don't think, let me just say it, that's the, I actually think it's not, I'm just making the point that it is sort of it's a, never mind, I think I should withdraw that point. Then I wondered about this 263, and maybe we could go down a little further. The whole discussion of from 263 to 273 about striking without the client's permission. It's a red. It seems to me it's a pretty radical. It's a radical idea. It strikes me. I mean,
But it's an obvious. It's radical, but it's obvious. Since you learn you're the captain of the ship, someone, as Teresa said, why can't you just? You're in the middle of trial. It's perjurious. The client won't remonstrate with you appropriately. Just tell the court right now you're striking the testimony.
So does not sink the ship?
I feel like I was.
Well, that's why when I thought.
I think what's really different about these two situations What's really different about these two situations that perhaps isn't fully captured here, right, is that when you assert your captaincy of the ship, right, in order to not present something, right, you're not making any disclosures to the court.
Right.
When you step up and move to strike testimony that you've already argued is critical to the case, right? Aren't you, as a practical matter, violating your duty of confidentiality? And so it's not just a matter of how far does the duty of your ability to be the captain go here, right? It's that you're actually in violation of, you may well be in violation of 1.6 by doing that.
Well, you haven't disclosed the confidence. You have taken action which is adverse to your own client.
I'm just saying, I just think that ought to be in the mix.
Well, I thought about it.
Yeah.
I thought about adding a sentence about the mere fact that you're doing that. That alone casts a dreadful adverse inference on the client's credibility. If you stand up in open court and strike.
I'm not taking, I don't have a view necessarily. I'm just saying that I think that it's more than just how far does the captain of the ship go is only part of the narrative. Because I do think that that could be viewed as really as an implied disclosure. If I suppose you stand up in open court, I'm thinking about, and say, without the client's permission, right? And say, I'm not going to rely on that testimony, but I utterly and completely disown that testimony.
Might as well strike it.
What?
Might as well strike it.
Well, that's what I'm saying. That is equivalent to saying, I think my point is that to talk about this, we need to maybe say, if we're going to go down this route, I think we need to say more about how it intersects with the confidentiality duty. That's all. I don't think California law is right on this, right? I think California law.
Right.
Correct. Yeah, that's to say, I think the model rule approach, which says that if at the end of the day your client won't let you correct, right, or excuse me, won't correct, I think you should have the right to correct. But California expressly takes away the right to correct, right?
Doesn't take away the right to correct.
Yeah, it does. I mean, if it would disclose the confidence.
Right.
Well, I think we at least have to think more about that.
I think the ABA rules are different, aren't they? Don't they explicitly say that the duty of candor trumps the duty of?
Yes. Yeah.
Sort of. They sort of, not perfectly, but.
No, they do. They pretty much say that, and California is so clearly does not say that, and that's part of what the tension. It seems to me that you're just. I mean, I thought this was a fascinating and really important idea. I just don't think that, as it's written right now, isn't quite defended. It isn't quite analyzed as deeply as it should be.
Because you should talk when you talk about this. Can you strike?
Yeah.
And the first question is whether you have the authority to do it.
Yes. And then a second
question, I think it's a matter of debate. So I say it's perilous.
Right.
Okay.
And I'm saying it might also
by implicitly you might be disclosing the client confidence.
I think at least with that it needs to be thought about as all as part of that analysis. Is all. I'm not taking a view. I mean, I still. You feel. Yeah.
We could even make the point that you guys were just making, which is unlike the ABA rule, which says such and such. Point out that part of the reason it's perilous, and part of the reason that that you have to consider whether it might disclose confidence is because California has a different provision.
like, you could even proffer the question, you know, attorney may analyze whether, you know, if possible, you know, if consistent with Rule 1.6, and then drop the footnote, or 1.6, you know, doesn't trump, you know, the duty of candor doesn't trump 1.6, but unlike the ABA. So in other words, you're proffering the question saying, the attorney should consider if they can, consistent with the duty of confidentiality, move to strike or something.
I'm familiar with the ABA rule and its comments, and it's really interesting, because many California attorneys think, believe it or not, hey, we're just, not many, but there are some. I've heard them argue it, that they make an ABA argument. So I could refer to the ABA rule. I know exactly where it is. You want me to do that?
I think Steve's point
We're
is
going to
good.
grow this.
Just almost in
I only have another year and a half.
Matt, I'm really just suggesting that you at least ought to flag the issue.
You know, I actually prefer to do it. I think, but it's really interesting, and so I'll do an ABA reference.
And those are my main thoughts. So.
Don't make me explain what a California lawyer's duties are when they go into other jurisdictions.
Fortunately, we don't write any conflict of laws.
I think that's changed now. Isn't that changed?
I remember what it used to be.
Choice of law ethics rule has changed. Now you get to follow the rules of the jurisdiction. where you
Really?
are. Yes. I'm pretty sure.
And these ones?
That's huge. All right.
I don't, you know, I'm not going to stake my life on it.
I wouldn't want to take your life if you were wrong.
Okay, good. But I can.
It's where the tribunal sits over the actual order.
Oh, really? That's a big deal.
What's that in?
Well, then the ABA rules talk about you got to follow this unless your jurisdiction provides for a different result.
Right.
Oh, that's helpful.
Well, the duties of the attorney are defined in the DMV code 6068.
It's right in the rule, the rules of professional conduct talks about the scope of the rules. It basically says, well, at least the old rules. I haven't looked.
Doesn't the DMV code trump the rules of professional conduct?
Yes.
Trump, but it's also,
It's the rules of
right, you can still be covered.
the jurisdiction which the tribunal sits, or
Right, and identifies both as
the
problems.
predominant effect of the conduct is in a different jurisdiction.
What, remember?
8.5.
Yeah.
All right, well,
Be careful when you go to the bathroom, you get locked out.
Well, oh my God.
You get locked
okay.
out.
I have a few comments.
Where? Here.
I do too.
Like, yeah. So we press this door, I have to go get someone to let me back.
So really, I'll go quick. Issues 1, 2, and 3. In issue 2, you struck if any. What the attorney's duties were retained in 2 and 3. I would recommend striking if any in both issue 1
Yeah, I'm
and
fine.
3.
I don't like this.
But whatever you choose, I would be consistent.
Well,
So what are the attorney's duties, comma, if any, as though there might not be any. And then same with issue number 3.
well, I actually knew what I was doing at the time, like I did, because on scenario 1, you don't have any duties.
Right.
I'm going to think about it. In scenario 2, you do have duties.
Okay.
So that's why I struck the if any on issue 2. So,
Okay, line 1.
You want me to take it out, or?
Well,
Take it out.
sorry. So that's my recommendation is take it out, but if you're gonna, I'd be consistent. It just seems silly.
You're right. You want me to strike them all?
Yeah.
Because I don't like them.
Okay, so we're done. Line, I'm trying to go quick. Line 126.
126.
So I have a question. The false testimony is perjurious because it was willfully given and meets the materiality element of perjury.
Yes.
We did not establish the materiality element of perjury.
Why do you say that?
Because where do you discuss that as material?
It's crucial to the outcome.
You're assuming it.
I say
No,
that.
it's in the facts.
It's in line 54.
Right.
It says it's crucial to the outcome, and then if you look at footnote 6, materiality means false statement that could probably influence the outcome of the
So
proceeding.
should we say it meets the material element of perjury because it is crucial to the outcome? I mean, I just think the
Yeah.
sentence needs
Oh, okay.
a little something. Line 126.
Because it's crucial,
Yeah.
okay?
And then, so we say this aspect, materiality, but then we go, if you drop back to lines 101 and 104,
101 and 104.
you added this, determining whether a witness has committed perjury involves the attorney exercising subjective judgment. Materiality may not become apparent until the
Right.
close of all testimony.
That's right, Andrew.
So, but it looks a little,
That's right.
it looks a little contradictory
No, it doesn't.
that it's subjective in
Detected that
scenario
a number
one,
of lines are connected.
and then
In scenario 2,
Is it-
there's no longer any doubt. You know that it's willfully false, and you also know it's material, so it does meet the definition of perjury. So I don't see.
said another way, I guess what I'm trying to get at is the sentence in scenario 2 require the subjective judgment of the lawyer to determine materiality?
Well,
Or
can we talk
has
about the
materiality
statement
been established as part of the case by the judge?
Well, nothing's perjurious until someone adjudicates it to be perjurious, and the time to appeal is run, or where you lose your appeal, then it's perjurious. So
I guess
that sounded glib.
No, I mean, I think I agree with you. My concern is when I read this, it seemed, when I read 101 to 104, that you can't determine the materiality. The lawyer can't determine materiality because
I said it's difficult.
Subjective. And then, and maybe it's just the suggested fix of saying because it is crucial to the case, by adding crucial to the outcome solves the problem. When I read the sentence about materiality in scenario 2, I thought, does this not contradict what we just said before, where we're making a determination?
Could I make a comment there, because it goes directly to this?
Please, save me.
Well, no, I think you're picking up on something really important, which is, I think, Matt, that you've gone a little too far in scenario 1 in your new edition about materiality. I think it's fine, but I don't actually think it's subjective. I mean, it's hard to recognize, it's hard to know, but ultimately, it's objective. I mean, it's either false or it's not false, and someone either intended to lie or they didn't. So anyway, I guess I think what Andrew's picking up on is we suggest in scenario 1 that it's subjective, which is almost like, who knows if it's perjury? And then over in scenario 2, we're like, it's definitely perjury. So I think the problem is only that 101 to 112 is goes a little too far. I think that what you're trying to say here is it's not, it's pretty difficult to know when something's material or when something's perjury.
It sometimes involves exercising subjective judgment.
I just say, if you just drop the word subjective.
Right, exactly.
Exercising
Judgment.
Judgment.
Yeah.
It's not subjective, because materiality isn't going to be judged by what a reasonable juror or a reasonable court would have thought.
I'm deleting the word subjective. Okay.
If you agree.
I do.
And doesn't that fix your problem, Andrew?
It does. Thank you for being much more. Okay, jumping to line 177, just a friendly amendment in the description of the 2015-192 ethics opinion.
I'm sorry. Where, what?
What is
177. Oh, it was on 177.
3 lines before scenario 3?
We cite the 2015-192.
Yeah.
Attorneys may disclose to the court only as much as reasonably necessary without violating the duty of confidentiality to demonstrate their need to withdraw.
I know, yeah, that's exactly, that's not a complete, yes.
I think that's one point. Okay, a lot of people talked about the captain of the ship and sinking the ship, I'll leave that. And then, in the conclusion, on 327, I don't know if juxtaposition or correlation is the right description here, but this first sentence and the conclusion, attorneys should be zealous advocates, true, I agree. But they are not guarantors that every piece of evidence presented to the court is truthful.
Those aren't my words. Those are just carry over.
So I don't think that second phrase is what is meant to be compared to the first phrase. I would suggest something from the sentence.
It's just a patchwork.
Okay.
I agree.
So I just raised it.
Right, I'll fix it.
So for my examples, just for you to think about, attorneys should be zealous advocates, but or yet attorneys may not use and must refuse to submit evidence they know to be false.
Right.
Last time, the money may not use or must refuse to.
It's the language from the third sentence, yet, it begins yet, so, yeah, but I'm happy to dictate the.
That's fine.
That's fine. Okay, that's it. Thank you, sorry.
I have some, you have some.
Yeah.
Paper.
I guess on page 4 of the red line, very bottom on line 50, we have the sentence attorney.
Line
150.
150, yeah.
Attorney in this civil case setting has the authority to refuse, and we're under scenario 2, to follow client's instruction that attorney knowingly submit perjured testimony. Would it make sense to say and must do so? I mean, yet you have the authority to refuse, and you have to refuse.
Right. Well, Andrew, in the sentence above, we say you cannot introduce it. Then used to say in addition.
Yeah, I mean, it's ethical mandate's clear, attorney may not solicit or otherwise seek to introduce testimony.
So, and then even when the client instructs you to do it, that ethical duty remains constant. So.
Right. I mean, it's not a big deal. You're saying you have the authority, but the same holds true. I mean, not only do you have the authority, you can't do it.
Right. Okay.
I mean, I'm not.
I think I can fix it.
Not a big deal. Jumping over to page 6. I'm wondering here at line 174, we say if client refuses, then attorney may move the court to withdraw his counsel without disclosing the perjured testimony. I just wondered if it would be, and remember, this is pre-trials, would it be more accurate to say without disclosing the fact of the prior perjured deposition testimony? Again, we're not at trial. I guess we're cleaning this up, so it's going to say continuing with the representation, but I don't know, maybe without disclosing the perjured testimony. It just seems like, I mean, it's the fact of the perjury. You're not allowed to disclose, right? That the testimony is perjured.
Yeah, you can't say I'm withdrawn because there's perjured testimony.
Right.
So.
On line 178, this is the parenthetical to 2015-192.
I'm sorry,
You fixed that already.
what page line?
It's line 177. It's just right below where we just were. So we're citing 2015-192. In the parenthetical, it says attorney may disclose to the court only as much as reasonably necessary to demonstrate their need to withdraw.
We added.
Yeah, we added without violating the duty of confidentiality.
Okay, I'm sorry. See, I told you a bunch of these were already done. My bad. Page 7, line 227. The client has requested to be, I would insert held before inviolate.
I'll check that.
Or, just check them.
Yeah,
The
it'll be-
language
yeah,
in
it looks-
606A.
Yeah, you're right.
I mean, he's not gonna request.
Well, it's a quote, so that I must have just left that word out. I'll see.
What word's missing?
Held, something like
Well,
held
it's
in line 220.
it's quoted right down below, it's maintained in the BMP code, but it doesn't have to be the same word, it could be held.
Where was it quoted from?
I mean, the client in this case is saying, don't disclose this, right?
Wait, Andrew, you're talking about line 227?
Yes.
There's some word missing. I have to go look to see what I was quoting from.
Client has rested. Oh,
I just think,
it's a quote though.
Yeah, it's a quote.
oh, it is, okay, all right. You're right. Well, somehow that sounds incomplete or missing a word or something.
Right.
Anyway, I just checked that. Flipping over to page 8, at line 237. You say, here the revelation that a key witness supposedly supporting client's case has committed perjury. Do we need supposedly in the whole, we've said how critical this testimony is on behalf of our client in support, I mean, I just put a question mark, why is it supposedly? I mean, there's no question, right? I mean, it's favorable, the perjured testimony is testimony that's favorable, not only favorable, but credible.
I'll delete supposedly.
Maybe at 241, if you already take, yeah, get rid of that, okay.
Yep.
On page 9, just 2 other quick comments. Line 290, or excuse me, actually it's 292, the paragraph that starts there. Attorney's continued involvement presents a risk to attorney of an ethical violation. I just wondered if maybe we should put in without corrective action after involvement, so it would read, attorney's continued involvement without corrective action presents a risk to attorney of an ethical violation.
Okay. Corrective action.
Over on 318. So page 10. Okay.
It's a quote from that 1983 opinion.
Yeah, there's some word or something seems like it's missing in there.
Okay, I'll
Which
just
could
check
subject
the
the
quote.
attorney to discipline, the attorney must conduct. Somehow there's some.
And I think that's it. That's it. I mean, my only other comment was when you when you get into the captain of the ship thing. I mean, the lead into that is, we say if the client rejects, this is 258, if the client rejects attorney's advice and objects to taking corrective action, attorney has further options. It's true. I sort of felt like maybe we should, and then I thought, well, what are the options? Well, we're basically, because when you read it, it sounds like you've got all these great options that are still left over. And then when I got done with it, I'm like, okay, so what were those options? There was 2 things. One, you can decide to strike the testimony as the captain of the ship, which we're saying is perilous. And the other is seeking to withdraw. So, I mean, I don't know. You don't have a lot of other options left over at that point.
Options is too optimistic a word.
Yeah, I don't know. I mean, I just,
Yeah,
He
you
has
have
some
2
other
options,
possible options.
Scylla and Charybdis,
Or
right?
something, I don't know. Go ahead.
Yeah. So.
Sell under the rocks would be court-martial.
I mean, when I got there, I thought, this is great. This is going to be some.
I can't wait.
Left over.
The first course was terrible. What are the other 2 options?
First
It's gotta get better from here.
Yeah, it's just like,
I mean, I like I'm not quibbling with the analysis, like, there's something about that lead-in just seems a little
Right,
too
right. It's
optimistic.
not really-
Yeah. So, are you good?
That's it, yeah.
So my comments are all in the third section. And I think it's fascinating and terrific what you've worked through in that. I mean, I guess I have a general question for the committee, which is, reading through this, I'm not sure. I think we ought to talk as a committee about whether we think this striking the testimony thing is really an option. Because it feels a little bit right now like we're showing all of our work and our mental processes, and it may be at a certain point we've talked through this and decided it's not an option. And then, I mean, there could be value in nonetheless discussing it. Like an attorney might, one idea that an attorney might have is striking, but the committee has concluded that's not an option because blah, blah, blah. So that's one thought. I think that just requires a little more work through.
Or to just have, I mean, another option along those lines would be to highlight the issue but not resolve it.
Right, yes.
You could input it,
Yes,
Well,
yes.
it would be
It's
really
unclear
curious.
whether
I mean, so
Yes.
the client, you can't remonstrate, the judge won't let you withdraw from the case.
Wait, let's just be clear about remonstrate. Remonstrate is, you always remonstrate. You just can't
Remonstration
successfully
is
remonstrate.
unsuccessful.
Right, okay, agreed.
Um,
Right, I think you don't, but I think
So,
the truth is.
so you can't withdraw.
Right, wait.
I would say
you
that,
withdraw.
so the judge won't let you withdraw.
Right, so then.
Okay, I'm going to, I don't care, I'm going to strike this testimony because
Okay.
this is BS.
Okay,
What could possibly happen to you that'd be bad? As long as you can prove it was perjurious, what, you're going to be, the client can't sue you for that. You gotta be
but
kidding.
would it be ethical?
No, I don't think you can do that. I feel pretty strongly about that. I don't know, I think it's a good point to raise to take a temperature about how people think about those issues.
The client can't sue you, the state bar.
Is there a?
For what? What?
I don't agree.
Well, if the one, it would be debatable whether you violated client confidentiality.
I know you're kind of.
But was it detrimental or embarrassing to the client? I mean, the issues that Steve raises is certainly worth exploring.
And it's potentially a violation of your duty of loyalty. It's,
Yeah, I'm now convinced.
Okay.
Once again, you can't strike.
So, okay, so if we conclude that you can't strike, then fine. I would say if we want to leave it in, we could certainly leave it in as a more fully baked analysis, which tells people, we've thought this through and we've concluded that's not an option. That would be fine. The other kind of organizational point I would make, though, is that I feel like assuming we were leaving it like this, what's going on here is you've got sort of three stages. First, you remonstrate, that fails. Second, you consider striking. Third, if you decide you can't strike, you withdraw, right? But I think you need to sort of walk through that more clearly, because where you move through the stages and you make clear that this is step one, this is step two, this is step three. Because let's see, so because here you say you could remonstrate, you could strike, and then you go back to, if on page 9 at line 275, if remonstration has failed, you can consider whether it's withdrawal. So that's kind of, I feel like you need to walk through it in a more kind of clear, just linear fashion. Like, if we really think striking is a possibility, if remonstration has failed, if you've concluded that striking is not available to you ethically, then your only option left would be to seek to withdraw. And then I thought that the discussion of the fact that you need to tell the client that withdrawing would cast an adverse inference. That might be better in the remonstration section, because I think that's part of remonstration, right? Is saying, look, if you're not gonna do something,
Yeah.
I'm gonna have to withdraw, and the
Right.
jury's that's gonna be at first. So I think that's,
Where's that?
it's on the bottom of page 9 of the opinion, so it's lines 308 to 315, or actually it's the whole last paragraph of the, before the conclusion.
Oh gosh, where is that?
The very last paragraph of the opinion before the conclusion.
In all circumstances.
Right. Right.
Oh, but it's not the whole paragraph. It's actually just the first sentence. Okay, so
Right.
just that first sentence.
Well, I did, that's why I said it in all circumstances, because I was saying, I figured people would pick up on it, that when you were remonstrating, saying,
Yeah.
there are a lot of things I can do here,
Yeah,
so hear me out. And option 4 is to me withdraw, which you don't want me to do that, because you're gonna look bad.
correct, but it shouldn't come here. It should come when you're explaining what remonstration would look like.
Okay.
So I apologize, it's not the whole paragraph, it's just that one sentence. All right, those are my comments.
Okay, great.
I really do think it's very interesting.
On that point about the motion to strike, it sounds like it might be worthwhile to find out what people think. I got the impression, like Teresa, I think you think you can, and so maybe that it's worth,
Straw poll?
yeah, just talking about it, about, you know, what's behind that, so that that has direction on
Well, what's behind it, my thought process behind it is, it may not be a motion to strike, but it's gotta be some way that you take out of the body of evidence, testimony that you put on, that you know is untrue, all right? So, motion to strike, you have an obligation under the statute, under 606A, not to present any information that would mislead the tribunal, mislead the judge. So if you leave information banging around out there that would mislead the decider of fact, you just gotta do something to remove that from body of the evidence, or you've gotta try to do something. A motion to strike is one way to do that. A simple motion to withdraw evidence, the same thing, I guess, you do that. But my point is that under the B&B code, you have to do something not to mislead, you have to make sure that the tribunal is not misled by anything you do. So if you've got that testimony out there, or any evidence like that that's out there, you know it's wrong, then motion to strike is what occurred to me. If we can think of some other way of doing that, but you've got to remove it from the body of evidence if they're the one that put it there.
Well, yeah, but what about Steve's point, which is the other part of 606AE, which is you have to maintain your client's all confidential information.
Absolutely. It doesn't, so absolutely, you don't have to say why you're doing it. It may negatively impact the client, there's no question about that. And you may, I think the first choice is to say, I gotta do this, or I gotta withdraw, you client choose. But if, but the point is, you can't ethically, client or no, under the client's instruction, I think if you ask for the client's instruction, tell them her, this is what you need to do ethically, you gotta remove it from body of evidence.
I
And if the
agree
client
that's
says,
what.
oh, I'm sorry, go ahead, I'm sorry.
I was just gonna say, I think that analysis is totally right, except that I think that California is really clear in multiple places that review of confidentiality trumps everything else. And I don't think you can really say that you're not disclosing something by striking that
Well,
testimony.
actually, it doesn't quite, because under the B&B code, that's what the confidentiality is. There's an exception to it.
Bodily injury.
There is an exception, right? Bodily injury, exactly. So there's that exception, but there's also the conflicting, which may be conflicting, and you gotta do something with it. You've gotta absolutely maintain the confidence and secrecy of your client, which you would be doing if you're not, I mean, there's a negative effect, but that's not the same thing as revealing confidence. And number two, you've got to not mislead a judge or tribunal.
So what's interesting though about that, if you actually look at 6068, that language, is that
you may never seek to mislead the judge or any judicial officer. And here, you put the stuff in, you weren't seeking to mislead anyone because you didn't know that it was false. And then after the fact, you learn that it is. So I don't think, I don't think it's the same, I don't think that is like an affirmative, absolute, strict liability provision where, if the court can be misled, you have to prevent it. So if you don't argue from it and you're not seeking to mislead the court with it anymore.
I would think that a lot of perjury comes up unexpectedly. A witness that's favorable to you says something glorious and you go, wait a second, that's a lie. But they just said it. I've never argued it. I didn't suggest they say it.
Left it in, and so isn't that sort of the...
You aren't going to argue it again. You aren't going to refer to it.
No, but you haven't...
It wasn't your fault. You didn't cause it to happen.
But it's
Well, you
there
were
in the
causing
minds
that.
of...
You weren't.
It's there in the minds of the
lacked
fact
the answer.
finder, right? It's in the
Are
mind
you
of the jury,
seeking
it's in
to
the mind of the
mislead?
judge. It's evidence that through your witness has come into the case. And if you don't use it any further, it's already been used by being there, isn't it?
Right, and the
It's
evidence-
an
Accidentally
interesting
and not
verb,
by
though,
your fault.
seek.
Exactly, and by doing that, as I say, you have to reveal the confidence or secret. If you've got to,
Maybe the
counsel or
seeking-
maintain, that's D, subsection D. Counsel or maintain those actions, proceedings, or defenses only as appear to him or her legal or just, except the defense of the person charged with public defense. To employ for purpose of maintaining causes confided to him or her. Those means only as are consistent with truth and never seek to mislead the judge or any judicial officer by an artifice or false statement of fact or law. And I get it, that you didn't seek to have this testimony, this false testimony.
Question, the issue of the truth is before the seeking, right?
Exactly.
It's already there before you get to seeking. So now
Right.
you've got a lie which you didn't seek to put in there.
But there
And
is-
you cannot seek to mislead the tribunal. So now you've got a lie, but you're not seeking.
Don't you have
So
to
it's
analyze this question in the context of assuming there's a scenario where you are not disclosing client confidential information by correcting, by striking? Can you strike? Because I think if there's confidential, if you're disclosing a confidential secret, a confidential information of the client, I think we would all agree, no. For the most part, I think we would all agree, no, you can't do it. But it does seem that, isn't the real question, if you're in a position, and I can't really conceive of one, where you could correct perjure testimony without revealing the confidential information, but say that you could, and the client says, I don't want you to, I don't want you to anyway, I don't care if you're disclosing confidential information, can you nonetheless go ahead and just seek to strike?
Wouldn't you be aiding and abetting perjury?
Aiding and abetting
Would it be
perjury
an
by not correcting
8.4
it?
issue? Enabling somebody else?
I think if you know beforehand, yes, but once it's in, what you're saying is not, there's some kind of affirmative duty to correct, and when does that end? But, whether there's an affirmative duty to correct is a harder piece, but I wonder whether, you can do it against your client's wishes if you're not revealing confidential information.
A really likely scenario, I think, is perjury happens from a favorable witness, client's friend. The client is surprised by it. You go, that's perjury. And you say, we need to do something. The client goes, I agree with you, that's bad, but will look bad. Just don't mention it again.
That's not client secrets or confidences.
Right, no, that's actually not addressed by, that scenario is not addressed by this opinion.
Right, but that's the situation in which you could say, no, we have to withdraw that or make some comment, because there's no 606
It's
I
not
don't know.
the client's fault that somebody
It's-
else lied.
It's not the client's fault. You aren't going to argue it because you know it's perjurious. You know that would not be right because you're endorsing perjury at that point. That would be unethical. Let's go. They said if it impacts the case, it impacts the case, but I'm not going to, in closing statement, I'm not going to refer to it.
But if it's in, then it impacts the case, right? Go back to this problem of, how do you just leave it in and say, I'm not
adversarial
going to.
system, that
Yeah.
there's another
That's why you have
lawyer who's supposed
cross-examination.
to be cross-examining,
Yeah.
doing a good job.
Yeah, the other lawyer ought to be on their toes.
It's not, I put it this way,
I'm so focused on the truth, I was like, oh, wait, never mind. Yeah. What she said.
I mean, Teresa, I hear your argument. I just think that California has rejected it. They just plain have, in the sense of you can't, there's so much stuff out there that says you can't correct false testimony. It's like a black letter principle, virtually. And it clearly is also the way that you can't. It's very, very hard, and I totally disagree with the way California does confidentiality as a matter of policy, but it's impossible to read 3100 to permit correction. You just can't do it. I guess 1.6 it's called now. You just can't read it that way.
Well, where to do so would result in,
Right.
in disclosing the client
Right.
confidentiality.
Yeah.
What if you could do it without disclosing the client confidentiality?
Well, if there are ways you could,
Yeah, could you do it over the client's objection?
right? Then it's
Do you have to, you know?
right.
In that circumstance, do you have to? Does the duty of candor to the court require you to do it?
Yeah. Well, I think that's an interesting question. Right?
This opinion can be criticized because it's opining that the lawyer went ahead and confirmed with the witness directly that the witness is confirming perjury. So the lawyer has independent verification apart from the client. The client led the lawyer to that discussion. But so if someone's going to say, I don't get it. Why is disclosing the perjury to the court disclosing the client's secret? You already learned that directly from the witness.
You've got the answer to that, right, in the opinion right now.
Because it'll make the client look bad.
Yeah.
But that's the
Is that
beauty of
all it
loyalty.
is?
Yeah, it's also protecting your client's case potential.
Right.
And it's not your client's fault.
I had this hand up right a long time ago.
So, I mean, if we're going to introduce the discussion analysis of the duty of confidentiality into the opinion, don't we have to also discuss that the information did not come from the client? And, I mean, there has to be some discussion. So for me, I think it's significantly different. The client comes to you and says, I lied on the stand. Your duty of confidentiality, for me, is much clearer in that example than if you learn, whether through the client or otherwise, a witness to whom is not your client, you owe no duties, lied on the stand. And I understand the main argument is, well, it would be detrimental to the client. Why? Because the client would lose the case. True. But you also owe duties of candor. You can't, it's almost like you're subverting the duty of confidentiality, which is to protect the client, to use it as a sword to win a case you otherwise would not win in an equal justice system of law. I mean, it just doesn't, it's not just that it doesn't feel right, I don't see how withdrawing or striking the testimony without saying more could be deemed quote unquote unethical.
Client secret means any information obtained during the professional relationship
I'm familiar with that.
or relating, which the client is requested to be held inviolate, or the disclosure of which might be embarrassing or detrimental to the client. It's a client secret. Even if you learned it only from the third party witness.
Right.
And you learned it during the course of representing that client, and you owe duty of loyalty to that client, to keep the client. That's a client secret, client secrets aren't, the only thing, there are secrets that you didn't learn from your client, right?
Yes.
You can't disclose, you can't disclose it. Once you agree that it's a client secret.
Right.
And the fact that the client's star witness has committed perjury is certainly at least embarrassing to the client.
And it also doesn't necessarily mean that they're going to lose if it's revealed. Part of what makes the client look bad is the fact that it's being revealed. Because the jury's going to go, oh, did the client ask him to do that? Like, what happened there?
Right.
And so, under this scenario, you have the client has their story. It's just that we thought they had an eyewitness, and in fact, they don't. But, the idea that, so what if the client is detrimentally impacted by that because he should lose the case anyway, isn't necessarily right. Although I could certainly see circumstances where it might be. But you still have client's testimony of what happened. And if you're going out there saying, oh, I'm going to correct it, it's detrimental to your client, not only as a client secret issue, but I agree. Maybe a duty of loyalty issue. You're out there now arguing, putting things in that are negative to your client's case. Against your client's wishes.
In part, Andrew, I think.
Which happened to be true.
Why's that?
Nothing.
No, it doesn't have to be.
Oh, you're in the wrong state.
In part you're struggling
I resign my membership.
with the difficulty of what a stringent approach California State Duty of Confidentiality. And not to put words in Steve's mouth, but when he says, I have a problem with it, personally because of policy reasons, but this is what they decide, that's fine. You're articulating a tension there in something that doesn't seem right, but part of that is due to the way, for better or for worse, California is interpreted to do. I don't know what there's enough here, personally, for myself, I have to think about it, but I do have some concern that loyalty could be leaking into this and so forth. And so, getting back to the original sort of point by Amy, I guess the question is, we need to figure out how much do we want to talk about this, right? Either do we want to set it up because we can reach a definitive conclusion if the majority of people think that you couldn't do this, but I don't know. We're hearing some disagreement on that. If we can't do that, do we want to maybe just flag the issue instead of getting into all of it? I think that's where we're at.
So I wonder though if we could. Did we get an answer to what people think about what Suzanne's question? Assume for a minute that you could disclose it without violating 1.6.
Right.
What do folks think about when you could do it?
Do you have to?
Oh, well, could you ethically do it?
Right. Or does duty of candor require you to do it?
What's left, I guess, of the loyalty?
Are you seeking to mislead if you don't correct it?
Well, I guess to me, okay, fair enough, but what if you can? Can you? No one's come up with this. Don't we have to add, otherwise we're talking about hypotheticals that,
You're saying don't skip the 1.6 issue?
Yeah, it seems to me the predicate is
Okay.
where do we stand on 1.6? Because, is there a way or is there a conclusion that this could be done in a fashion that doesn't, violate 1.6? Because if there isn't, I don't know what it is.
So
maybe there is, but I'm sort of waiting to hear what it is.
Wait a minute. Oh, okay. So, I actually think with 3.3 the way it is now, you do have to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Yeah. And then, you might have to correct it independent of 1.6. I do think you shall take reasonable remedial measures. So if you take the 1.6 out of it, it's not a very interesting question because I think
then
it does require you to take remedial measures.
Right.
So
the 1.6 is the issue.
Right.
And so, Teresa, were you thinking, in your view, it's not a revelation of client secret to this?
That would be my view. I mean, I absolutely agree with you that inability, that you absolutely not reveal a client secret. You would have to, if you made such a motion, it would have to be without any additional information. So I absolutely would agree with that. It could have a tactical disadvantage to your client. There's no question about that. It could put them in a tactical disadvantage within the trial. But that's not the same thing as revealing a client secret. I mean, duty of candor to the tribunal comes before that.
Before what?
Not before revealing a client secret.
Right.
But before,
The negative impact.
whether or not it has a negative impact on the position of the trial. Yes.
Yeah, decide. I mean, I do sort of think a motion to withdraw is the same thing. I mean, motion to withdraw, everyone knows why you're withdrawing. At least every lawyer knows. Maybe the jury doesn't.
But the adverse
Jury
inference
doesn't know, right.
that results from a motion withdrawal is permitted by the,
Yeah.
you should discuss it with the client, but you're permitted to commit an act that creates an adverse inference.
It's interesting, that is, I guess that somehow there's no connect. You could argue that adverse inference is effectively revealing client secret, right? It's revealing information. But you're right, it's right in there saying you can do it, so maybe by analogy, you can move to strike. It's the same inference essentially is being made.
I think in terms of the sequencing, I mean, my view, and I think about if I was advising a client on this, it would be obviously the remonstration issue, and part of that is a discussion about what you could and couldn't do in the context of the representation going forward. But I would then say, if you're not going to agree to let me make this correction, then I'm going to have no choice but to withdraw. And that's the step that I would pursue.
And that won't look good for you.
I agree, and it won't look good for you, and I think it's unlikely that a court's going to allow it. But I personally would want the person to tell the client and to try to take that step, because then you're saying, like, I'm conflicted, and so I think in terms of the discussion, and people may disagree with that, but I think that, you know, you're trying to do something to put you in a situation where you're not violating these rules, and you're because of the client confidentiality piece, which I think is really important, and I don't, you know, I think it's a problem, and I wouldn't want to be in a position where I'm saying, like, which is more, I'm weighing these two things, and I'm having a really hard time concluding, you know, which is the most important piece, especially in this fact pattern when the client specifically told you that piece of information. And then if the court didn't allow you to do that, you know, then I think there could be a discussion about what further steps could you take. Is it simply enough just not to refer to that evidence further, or, you know, could you take this additional step and we may not reach a conclusion about whether or not.
I completely agree with you. I mean, I think the very first step you should take, or the first alternative you should take, is if you check with the client would all agree to remedial action, then you must ask the client's permission, ask the court's permission to withdraw. If that is declined, then you have to think, number two, with the client again, demonstrate with the client, to take some sort of corrective action. And you know what? That maybe that's not striking the evidence. Maybe that's introducing additional evidence. It's possible. That corrective action could be something other than striking the evidence. But one way or the other, that the perjured testimony has to be neutralized, or you have to do something, or try to do something to neutralize it. But I completely agree with you, Dina, that if you're faced with that and the client refuses to do that, withdrawal would be totally appropriate.
Except for that, if you can take corrective measure without violating Rule 1.6, you have to.
Yes.
Even if you ultimately withdraw. So that sequence is not, you know, it doesn't go remonstrate, withdraw. It goes remonstrate. Can I correct without revealing confidential information? If I can't, then withdraw. Then if I have to stay in, what do I do?
That makes sense.
It's not that bad a policy. I mean, perjury rarely is this clear.
Right.
So you get the luxury of saying, well, I'm an advocate, and I know it's subjective, and what is materiality? And maybe it's a necessary luxury. But people really aren't during a trial running up and saying, I just lied.
Yeah,
right?
yeah, just
I
like,
know. Yeah.
yeah.
You're right.
I mean, it's far more murky, and people go, oh, I'm under number one, I don't actually know.
So where does that leave us as far as giving that direction? I mean, on this section, we would leave this in and have him try and fold in some acknowledgement to the confidentiality issue and see what that looks like. I don't think we're gonna reach
Under the question of striking?
Yeah.
Yeah, I plan on doing that.
Okay, so maybe.
That possibly, another reason, you first have to question your authority, and then the other problem is you may be by inference.
Well, here, one of the things that comes out of this, I think Suzanne's formulation is wonderful. I know you have to run, so I'm not going to hold you. I think you should think about Suzanne's formulation, right, which is demonstrate first, right, but that correction is always required if you can do it without disclosing of confidence, right, and then you can get into the question, because you don't actually have the authority not to correct.
Right.
If it's not a confidence.
But
So then that kind of leads, may take the captain of the ship out of the picture in some way, because if it's not a confidence, right, not disclosing a confidence, you have to correct.
How could you correct without it being detrimental to the client under these facts?
Well, that's, I guess, that's the question that has to be worked out, is whether there actually is any space for correction that doesn't violate the duty of confidentiality.
Well, what you'd really do is you'd say to the client, we're going to turn
Yeah,
this.
that's the duty of
Right, or sink the
confidentiality.
ship.
Yeah, well, sink the ship, I think sink the ship drops out, because sink the ship is not, if it's not confidential, sink the ship drops out, you have to do
Suzanne
it.
has pointed out that there isn't a sink the ship, you don't have, if you can do it, with satisfying your duties under 1.6, you have to do it. So it's not really a question of your authority, it's a question of.
It's just a question of whether there's any scope in that at all.
Right.
Really.
Have we identified an example in which that could be done? Because it seems to me everything that could be done would result in detriment to the client. Client's case would be arguably irreparably damaged if this is the control testimony.
I hear what you're saying, and I think we all have our frustration with how broad the client secret goes.
No, I think I'm being convinced of your argument. That's all I'm saying.
I do think, like, if you were walking down the hall and you overheard, the client talking, the witness that just testified talking to somebody else, and he's like, oh my God, I just lied, or whatever, which of course is ridiculous, but if you overheard something, you're getting really far away from the attorney-client relationship, and really far away from, what most people would consider client confidences or client confidential information, but technically it may still fall within that broad definition, but I think you're getting a lot closer to, you're walking down the hall, you see the person, they say something, whatever it is. They were going around in a wheelchair saying they can't walk, and then you see them in the parking lot and they're running, right? Stuff like that. Oh, wait a minute, now, is that really a client secret? Is that really a client secret? But I guess you could say technically yes, could you acquire the information during the
Are you gonna go and say, I wanna testify, I just saw the guy running out in the parking lot? You're not gonna say that, right?
No, but you now know, it doesn't really matter how you correct, but you now know that testimony was false. So I'm just saying, I can envision maybe a circumstance where it's not confidential information that is causing you to know that the person's lying, and then you might have to correct.
We have opinions that say you learn a bad fact about the client that you learned from somebody else. The client is not the source of that. This activity, I said, you can't reveal that.
It's in the course of your representation.
It's a bad fact
Right,
for the
if you're
client
interviewing
that their
people.
star witness is a perjurer.
Right, but so what if you're out to dinner and you see the person walking, you shouldn't walk. Is that in the course of your representation?
I don't know. I mean, I think that the very broadest articulation would say, yeah, because you're representing them, you wouldn't even know that
Well,
person.
the revelation
If
of
you
the
didn't write
learning
it
that
out.
would be detrimental to the client. I mean, it gets back.
But it has to be
To
in the
that
course of
point.
representation.
Right. You have to have acquired the knowledge in the course of the representation, which has to have some kind of causal connection.
Matt, you have enough, right?
More clarity if you're introduced without question. I
want to take a quick break, like a 5-minute break.
Are we done with mine then?
Yeah, I mean, unless it seems like.
Yeah, you have plenty to work on there.
No, I mean, it's a great, I said it before, I
With,
think it's
I
gonna
mean,
be
yeah.
a super great opinion, it's gonna.
Yeah.
I would just throw
It's
out the
really
caveat, I
It
would
is.
throw out the warning, that we got a lot of long opinions, I don't think this one needs to get much longer, it keeps growing, I think.
I hear ya.
Pretty tight.
What's been added has been pretty useful, I think, based on what the community wants to do.
So are we off? We're gonna go offline for about 10 minutes.
Well, we don't have a lot of time, but I think, why don't we go ahead and do the 13.003, ethical obligations when departing a firm. At least realizing that on this opinion, we have a number of people that are leaving. One of the things that I thought we could do at the time remaining is if there are any comments from the subcommittee members that are departing, which is Ujvala. Joel's not here, so obviously we won't get comments from him. And Suzanne, I don't know if you guys do have comments, but if you do, it might be good to focus on those first so that Nina has the benefit of that since you guys are leaving. And then I'll just throw out sort of generally for everybody else, this is an opinion where we could use, if there are other people that are interested in coming on to this opinion, as I mentioned, we're losing 3 of the subcommittee members. So might just keep that in mind, let us know. So yeah, the red line starts at page 63 for materials. And so I guess I'll open it up to Suzanne and Ujvala first, and then maybe just...
I'm trying to go there. Okay. I find this this opinion really interesting because it's more of, it's a little different than what we normally do. It's more of like a primer on what to consider. And so it's a different format, and I think you're doing a really nice job with it. I mean, I'm concerned that it's long. This has always been an issue with this opinion because it started out as like a gigantic, 30-page or something outline of issue spotting. And so I would encourage some shortness, and to that end, I mean, I see some principles that are repeated, throughout, which is that the client comes first, and that's obviously true and really bears repeating. But even like in the first 2 sections, I remember thinking, are we just repeating here what we already said? So I would just be conscious of that. I want to just give some more general comments rather than like drill in on your specifics, and I saw some little things I'll just shoot you. But those were my overall impressions were that we needed to really focus in on what specific things we want to say, and I thought the first 2 sections in particular, we kind of come around both times to the client comes first. And I thought, should we just either pull out that concept as its own and say that this concept that the client comes first is woven throughout several different things, or do we just continue to weave it where we see it? So these are more structural comments and feedback that I would have, but that's what, those are my primary things, in addition to some really smaller ones that I would.
Okay.
But I know that, Dana, you wanted some guidance from the committee on where.
Well, yeah, I mean, it was
what to go.
definitely,
Yeah.
I mean, the discussion that we had initially was that it would be more suited to this format as opposed to hypothetical and advisory. There's certainly a lot of issues. I mean, initially with the outline, I suggested leaving some of the issues out, and there was people wanted to put those issues back in, and so it is, it is long, and it probably, that's part of the thing that some of the stuff could be tightened up. I mean, I think there's a lot of time, I do spend time going through some of the rationale behind it, whether people may or may not think some of that's helpful, some of the history behind that. And then obviously there's a lot of factual examples of things which, when you don't have a hypothetical, I think that's helpful to have, although there may be, too many of those. But I think, well, I'll just leave it at that. I mean, I think that, yeah, the central theme is that the client has to come first, but I think people know that, but then they don't always actually know that, which is why I think that, in these different scenarios with different rules implicated and different examples helps highlight those particular points, but it certainly could probably be tightened up for sure.
Yeah, it's just a thought. I mean, it's not something, I just don't know. Sometimes when I keep seeing repeated themes, I think sometimes I should just pull it out into its own section and then do it the other way around, but I don't know that that would work here. And the thing is, I really like your writing style, and I like what's written, so I'm kind of compelled by it, but then all of a sudden I think, oh wow, I'm really reading a lot of stuff here, a lot of background information. And as you go through, you might start thinking, let me just pare it down.
Yeah, and the outline was like the structure that I worked with that was existing at the time,
Right.
and so that kind of dictated sort of the different, and I'm not saying that I think those structures are, I mean, it had a good structure to it, but that's just sort of what was there, which I took and then did, you know, so.
On the client choice point, I mean, section 1 is set up as a section at the very beginning that says the guiding principle is client choice. I think you're right, where we can tighten and we don't want to be repetitive and so forth, but I also think in these situations as a practical matter, to Dina's point, I mean, that's the thing that so many people lose sight of. And so I actually like the fact that in addition to setting it up as a guiding principle, then when you get to the different phases and stuff, I think it makes sense to show how that guiding principle, should be applicable or what it should be doing in that particular phase, and where so many people forget it. So, I mean, if we just say it's a guiding principle, I don't think that's enough. I agree we don't want to be repetitive, but I like having the examples in the different phases of here's how that helps sort of guide what you're doing as to this sub-question or issue that we're talking about.
Yeah, and maybe one way to address that is to make the discussion in section 1 more robust. Bring in more of the slightly deeper discussion of the guiding principle, rather than just state it, this is the guiding principle. And so that way, later on in the document, it's just a way to think about it, is you can just touch on those ideas without having to explain them sort of in each time.
I would need an example of what you're talking about.
Okay, so for example, when you talk about towards the end of the first section, the client retention credit, idea of client as property, this idea you really fleshed out nicely later on in the opinion, particularly in terms of the communication, is that you cannot use communication as a tool to prevent the client from having the client's choice. You can't prevent the departing lawyer from communicating with the client just so that you can get there first, persuade the client first. But until I get to that point in the opinion, the idea of communication isn't front and center for me. And maybe I just missed it in the way it's woven in, but maybe there's a way to bring it into the beginning of the opinion to say, look, the communication with the client has all of these implications. Has the implication that, it's not just that the client gets to choose counsel, but also that it's, that it is not used as a, that it is implicated in the idea of the client as property. Wrong. But, those are, I think, just, stylistic issues that I'm sure we can work out. I really enjoyed reading this, and I agree this lends itself, the topic lends itself really well to not having hypothetical and having it be this type of a discussion. And I really liked the examples because they really flesh out the idea. And I think that way it works really well. The one I thought I had from gathering things was that I thought the duty of competence was came up in a couple of different places, though it has its own section. I would put that to put those issues together. Because as I was reading it, I was like, oh, here's competence.
What two
and then
issues?
The issue of the duty of competence, which is section 4. But there's a it's a very short section. And then in the context of another discussion,
I withdraw, I don't know.
right, it's withdrawal, yes, you cannot. And so maybe, and I'm not sure structurally how you would do it, but you could maybe combine those two sections or find a way to, not, or put them right next to each other so that you've got duty of competence, when you go into withdrawal, and you say, it's implicated, and then discuss withdrawal, so that you don't read about it and then get to it. So those are just some of the structural, but I really liked it. I had a few small issues, I'll just give them to you, they're just edits.
Can I ask you guys a question? For Dina, or out of my own curiosity, one of the things that we talked about and struggled a little bit with early on, as I recall, with this opinion was, there's going to be this tension between the ethical issues and sort of the lawyer, partner, fiduciary duty type issues. I wondered, again, just since you guys are leaving, what your reaction was to how that's being balanced here. I'll tell you mine, but I guess I'm going to call it. So that, I think that would be helpful to get the impression of, right?
Yeah.
I think it's good this way. I think it's good to highlight it and say that there is the fiduciary duty between the partnership to the partnership, that it exists. Don't forget about it, but that's not what we're going to talk about here because it's not within the scope of, that's a whole different opinion of its own, I think. I think it would color this opinion in a way that would detract from the client-centric. You touch on it, and I liked the way you said, look, it's good to have policies in place in the firm, but if those policies start to erode the importance of the clients, putting the client first, then those policies should be reconsidered. So it flags the issue for people, and I thought it was good to keep that as a separate, rather than being that here. I think it'll take it far beyond.
I agree. What I got from this mostly, and I think it's sort of a definitive statement, and I liked it because I agree with it, was, you're going to have these other obligations, whether contractual, fiduciary, or whatever they are, but they don't trump the obligations to the client. And that's sort of woven throughout. And as long as that's the conclusion, I do agree with it. And I think it's important to flag them, mention them, and then don't get bogged down in that. Because that's where a lot of this opinion, the earlier iterations of it, was getting bogged down in what your obligations were to the firm or to others. And, it raises questions like, am I required to expose myself to civil liability to my firm because I'm complying with my duties of whatever to the client? And that's a scary space to put lawyers in, but at the end of the day, I think that if they had to, they be faithful to their obligations to client, they might have to expose themselves to civil liability to their firm. But you don't need to say that. I was just very conscious of that. But it's a really sticky wicket because of that. So, I think the way it seems to me to be developing, it seems like a good way to treat it. But I am curious, I don't do as much defense work and counseling work as you guys do, and so it might be something that's a little bit more uncomfortable from your point of view. I'm curious about that.
Well, from my perspective, I really like the way it balances flagging the issues, which I think is important. But sticking, we're not telling you the answers, we're not, but I think it's important to flag them. And before, I think there's been some sensitivity by some people where it's like, we're talking too much, you know, if we have 5 things in the opinion where it makes reference to some fiduciary duties or whatever, you know, they were overly, in my view, overly sensitive to that. I think the flagging the issues is important. And I sort of like the balance you have right now, you know, pointing out where those things could come up. But again, you have sort of this underwriting ethical principle, which is, you know, re-emphasized consistently that from an ethics standpoint, you gotta put the client first. But I think it would be kind of a disservice not to, you know, give people, you know, a flag that says here's a situation where when you're considering what you got to do ethically, you know, there are other issues implicated. We're not saying those trump or that those should drive the determination, but you should be aware that they're there.
Well, the solicitation issue is one of those issues which is a little bit different than what you identified, which is like where you'd say more like it was an ethical imperative to act a certain way. That's something where you're permitted to do a particular thing, but in that case, it could implicate issues related to, you know, future duties to partnerships or things like that. So I think I was trying to stick with just like it's ethically, you know, there's nothing ethically wrong with doing that. It may have other implications, you know, to your firm, to,
right.
But not to suggest whether how that would come out on, you know, 'cause that's, like you said, sticky wicket.
Right, and that's a good point, like the difference between what you're ethically required to do and what
Yeah.
you may do,
Yeah.
but then you may
Yeah.
be prohibited from doing under other obligations that you have,
Yeah.
so.
Steve?
Quick question, do law firms require associate attorneys to sign non-competition clauses as far as taking clients within the company or anything of that sort?
I would say not, it's not,
very
it's
difficult
not
to
the
enforce that
typical
against
thing or the normal
Yeah.
thing for a law firm to have
Yeah.
an associate sign,
Yeah.
something like that. Law firms do have all sorts of, I mean, partnership agreements
Also
for a law firm can vary in terms of what they provide for, and there are all sorts of efforts to put in sort of disincentives, shall we say, or, you know, competition, restrictions that are within this, and by the
Or
way,
even like
there's
liquidated
a body of
damages.
law that speaks to the extent to which you can sort of put in a restriction on someone's ability to compete. So all of that is kind of factored in, but it's more the partnership agreement and the partner's obligation, fiduciary obligations to each other as partners. I don't think I've ever seen a firm that has an associate sign something that says you wouldn't be able to compete.
I was asking the question in the context of the opinion stating that the attorney should inform the client on line 312, the client's option to stay with the old firm, go with the party lawyer to her new firm, or choose another lawyer or firm entirely, which makes perfect sense to me from the point of view of putting the interests of the client first. But that's why I asked the question about, this says the attorney must inform the client that they have the option to go with the attorney leaving to their new firm. I didn't know if there were co-conditions that pose ethical conundrums to attorneys that need to be mentioned. That was why I asked the question.
It's pretty well established from an ethical standpoint that the lawyer and law firm are supposed to tell the client that the client has these options. Whether in doing that, there's some parallel pressures vis-a-vis the partnership agreement, you know, as to the lawyer, if the client decides to leave with the lawyer. I mean, there may be some tensions. That's part of what we're talking about.
I mean, a non-compete in a very direct way would not be considered likely to be valid and enforceable, but different ways that firms treat different language, disincentive provisions or otherwise, could be viewed, notice provisions, lengthy ones, as, you know, and sort of a restriction on the right to practice law, how that could be interpreted versus the client's right to choose and go with whoever they want. There's a tension there, which is not going to be resolved in this.
I have one question. I mean, we don't have much time left, but if I can. On page 7 of the red line, at line 256, so you make this point that
I mean, here you're talking about, I think, communicating the fact that you're gonna leave to the client before the firm. I mean, and you're sort of stating the general proposition with respect to the departing lawyer, absent circumstances that would prejudice the client's interests or interfere with their right to choice of counsel, the departing lawyer should not communicate the fact of the departure to her clients until the old firm has been informed of the departing lawyer's intent to leave the firm. And then you go on to say, while there are limited circumstances in which a client's interests may justify notice to clients before the law firm, in such cases, the departing lawyer shouldn't use this time to her unfair advantage. And you have footnote 5 and you drop it down. And so, I mean, you're sort of saying, generally speaking, you shouldn't be telling the client before you tell the law firm, absent certain circumstances. And you drop the footnote down. You say one example is the departing lawyer needs to check for conflicts of interest with the current client prior to accepting a position at the new firm. I'm just trying to understand the example in 5. I mean, part of me is thinking, well, why would you have to tell? I mean, if you're thinking about going to another firm, and part of that decision process is going to require clearing conflicts to come over, and maybe this is a client who might be inclined to leave with you, and so their name is going to be something you would provide for purposes of clearing conflicts. Why? That has to be.
Well,
I mean, why do you have to tell the client I'm leaving in order to talk to a prospective new firm in clearing a conflict?
Yeah, and the examples that I'm thinking of are circumstances, and it doesn't come very often, where you maybe have a client that is really only wants to work with a particular lawyer, they have a long history together, that's that type of client relationship, and that client itself, may have restrictions on different firms that it would be willing to work with. Like we wouldn't go, if you moved your practice to X firm, we wouldn't do business with that firm for a variety of reasons. And so there may be reasons that, and there may be other conflict reasons that the, internal reasons to that client that the attorney may or may not be aware of at the time. In other words, even if they cleared that conflict with a potential firm, it doesn't mean that that client's going to be happy about that.
So then, if I understand, it's not so much clearing the conflict. It sounds like what you're saying is your decision whether or not to go to a particular firm might be influenced by the willingness of the client to go to that firm. Therefore, you're going to disclose before you make the decision to that client. You're going to get some sense of, hey, if I go to this firm, is this a type of firm that you'd be willing to work with?
And that's that's kind of a rare situation in which you really have, like I said, there's not going to be necessarily a question about whether that client, and I know, that's the fundamental question, is what would the client decide to do, and are you really taking it upon yourself as the attorney to decide, well, of course the client's going to come with me, and so, I need to vet this, but I have had examples where, and the conflict refers to sort of like the internal, in a corporate entity structure, like their internal policies on which firms they would do business with, and like that, and sometimes it's based on conflicts, whether they're legal conflicts or other conflicts. And so I think that's an example of a situation in which the client would want to know if you were leaving that firm, because where you would go maybe be influenced about their ability, to take work with you and move to that firm.
But you're not saying that just for in basically any lateral movement where you're going to be asked to provide some information by the potential new firm to run conflicts, that would necessarily mean that I have to go to my clients and tell them in advance of the firm to clear, right?
Yeah, and I think that needs to be cleared up.
That was just a little bit. I was trying to figure out.
That's not what I'm saying, or I think we should say. I mean, I think that the conflicts issue is its own issue that's kind of sensitive too, in terms of like the identity of the client, and as we've talked about, we are all very well aware of the case law surrounding 1.6 and the other obligations that it's tricky about when you are trying to make that transition. Whether what you can disclose ethically is always a question, and whether you need to get consent depending on what you're disclosing. But I
didn't really get into it.
No, it sounds like you're focused on a different, it's more
Yeah.
the client's knowledge about this is sort of a prerequisite to me making a determination about whether I will make the lateral move,
Yeah.
I guess.
No, I see it on my end right there. I'm watching it.
Okay, well,
Can I just have
Yeah.
a point, because we're on just that same area?
sure.
No,
And
I
it's
have
really
a-
interesting
I
to
have
me,
a-
because it sort of
yeah,
gets at this question of
they're actually
fiduciary
going-
and
they're
legal
doing
obligations versus ethical. And I felt like,
and
just the section Drew
and
just read,
even if it does stop,
the lawyer, the departing lawyer should not use this time to their unfair advantage. I think that's true because of legal and even fairness considerations, but I don't think it's true from a client-centric ethical perspective. I frankly think that if all were, so I think we have to be clear about that, because I think this admonition is not growing out of any ethical issue. And frankly, it's in the client's interest to know as soon as possible. And if we were owned, so that, I mean, it's just an interesting moment.
Yeah, no, I'll look at that language, I mean, that's a good point, I think. You're really talking about something besides I mean, it all kind of dovetails into that concept, and it's like how you're gonna compete with the client, what's the right way to quote unquote compete, and,
Right.
you know, in a way that, I mean, when you're giving a client choice, and the client's the choice in some ways, I mean, you know, in theory, want to present that, just in that way, give them the information that they want, not try to unfairly color the you know, but that's really more of a concept of what you're talking about. It's sort of not more really an ethical issue, it's more of the
And I just think we have to watch that, I mean, 'cause it's quite interesting. I mean, really, I don't think you can, firms can't justify like rules against telling the client in advance based on ethics, I don't think.
Could there be an argument, or is it a solicitation event perhaps?
Well, so I had a whole question about your discussion of solicitation, because I was totally confused by it, since I think both the firm and the lawyer have a prior relationship with all these clients presumably. So I don't think the discussion, which I can't find now, of solicitation, is what's more confusing to me, because I figure, I don't think any, well, so I'm not in the red line, I'm clean, but it's page 9.
I had the same question. If the person is somebody that you're going to give notice, that you have to give notice to the client that they're leaving, right? Doesn't that answer the solicitation question? Doesn't that mean that they had a prior professional relationship with the client?
Right, so specifically, say that again, what you're asking about that.
It's maybe a just slightly different question from Amy's, but I think it's capturing the same idea, which is we say that there's a group of people where you've got to notify the client about their departure.
Yes.
Right? There's got to be notice of their departure. And it's because they have some kind of professional relationship with the client.
Yes.
And that the client would regard them maybe as their lawyer, or at least as someone that like to consider it as their lawyer.
Right.
Right. Why does that mean that the solicitation question just drops out of the equation?
Well, no, there is a distinction in a lot of these cases and discussions, or in, I shouldn't say cases, but in the ethics opinions about you're talking about the difference between notice and solicitation. So notice, and the cleanest version of notice is saying, like, here's what I'm doing, okay? This is what I'm doing. I'm leaving on this time. This is what my plan is. I'm going to this firm. This is what my team is. My practice is going to look like this, and you have these choices. Solicitation is saying, I would like you to come with me to my new firm. And so the question about, there are people that don't think that you can solicit your own clients after you've, before you've left the firm.
But it's not because of the ethics.
Correct, which is what I thought I identified here, which is like ethically this is permissible, like you can do this, because there's this misnomer that this argument that comes out that you can't do that. Now whether there's other issues that are implicated by whether you can do it after you've given notice before you depart, I mean that's a huge issue in this area where firms, and there's a lot of discussion, argument about like, well, once you give notice, you can't basically ask the client, you can't tell them you want them to come with you. And I think it's kind of a ridiculous concept, and there's discussion about it, but that is an issue that comes up all time and time again around this, which is just that. And so the point here, whether it's clear or not, is to say that you can do this from an ethical perspective. There's nothing prohibiting you from doing this. Whether you might run into other issues about
under unfair competition law
and breach of fiduciary duties and things like that, that's a separate question. But and there's an argument that Hillman's talked about. But is it?
This is your discussion, I think, like in the red line 409, where you're saying that from a purely ethical standpoint, the same rules that permitted an attorney in certain circumstances to solicit clients, rules 7.173, would apply here. The question of whether such conduct will violate fiduciary duties between partners or amount to unfair competition is an open question. It's likely to be fact specific. So I do think the discussion starts at 403, where you say finally questions often arise about whether solicitation is permissible after the departing lawyer provides notice of the old form of further departure. I put beyond the notice question mark. I mean, it does need to be clearer. I understand what you're saying, but the solicitation is not the notice or it's the question of whether the lawyer can actively encourage the client to come with him or her after notice has been provided is a fiduciary duty question for the partners or whatever.
Yeah, okay. That's
solicitation without more is a little bit.
Because there's a lot of discussion regarding notice and solicitation in other contexts that aren't really the law firms involved with clients. And you have you can notify clients at your meeting, but what does solicitation mean? And that's just this. So people often you can't solicit, you can't solicit.
Right.
And it's this big
But
thing.
solicit is like a term of art from an ethical standpoint.
Right. Yeah.
I just think, Dina, if you could probably dispense with this more quickly and more definitively by basically just saying the solicitation rules, the ethics rules don't have any impact here because there's a prior relationship.
So not going through this discussion of
I don't think you really need to very much. I mean, I think you just say they depend on. I mean, 7.1. It's true. Of course, you can't be false or misleading. But I'm not sure you need to say that because that's true of all lawyers at all times. I mean, I think we can pretty quickly dispense with the notion that the solicitation has as a term of art under the ethics rules is relevant here because if there's a prior relationship, it doesn't apply. Right?
What about the discussion later on about the
Or it's not barred.
Okay, that's fine.
Because there's a discussion about soliciting in a manner that involves intrusion, coercion, harassment.
Oh yeah, that's all fine. It's just these two
these
paragraphs that got really detailed in a way that I thought ultimately it's like in the end you're going to tell us that you need to work on those.
Yeah.
All right.
Thank you.
It's 5. Let's adjourn.